the whole of the province will be governed over the next 4 years by an irregularly appointed, and then it went on to deal with. I just want to stress the analogy to say two things. One is that we know that when we're dealing with preliminary issues, the court has to assume we're correct on the merits. And that's why the court articulated like this. If it turns out it's true, it didn't mean that it was true, but for it to be assumed. And secondly, it said for the whole time the province would be governed legal government as it were. Same thing here. We're saying if it turns out that we're correct, then the rest of the commission will proceed on the basis of an illegality and patent bias. If we're and it said that paragraph 18, the appellants were denied the opportunity to have the merits of their application heard on the basis of technical procedural grounds. They've come to the conclusion that these grounds were incorrectly relied upon by the High Court, and then it went on to evaluate all of it. Then in paragraph 83, the court said that this would mean that this court would be the court of first and last instance as far as the merits are concerned. Although this consequence is unfortunate, it was, in my view, necessary to go through this route. I might punctuate that by saying that the court in Ramakatsa, what it did to circumvent this problem was to ask both parties to supplement their paper so that this court would be able to deal with that. It's more. In this case, that's not necessary because we have a full set of papers and the matters were fully canvassed previously. Lastly, on that score, why I say this case is better than Ramakatsa with respect is that in that case, that was a single judge. Here we had a full court. In that case, we only had the views of the court on the technicalities per se. Here, we do have, albeit in a minority judgment, the wisdom of the lower court on the merits. And on those basis, we say that the cases are similar, but this case has got much more commending itself for the procedural issues to be ruled in our favor. Then I move to what I call part 2, which is the legal issues that have been raised. I will raise through quickly the other 3 so that we can then come to the main issue of Section 47. The one issue is that has been raised is that the application has been brought in medias res. In our respectful submission, there's no merit in this submission for the reasons that were very well articulated by Mudiba J in her judgment, namely that this matter is not so much about the outcome than it is about the illegality of the process itself. In other words, irrespective of the outcome, whether it's good or bad or different, the process itself would have been tainted by illegality, and therefore it's an exception to. Secondly, in our respectful submission, this case, and this is linked to the exceptional circumstances around direct access and so on. This is a case where the exceptional circumstances, the serious nature and the legal implications of the matter for both sides speak for themselves. And therefore, even if one were to approach it from the test of grave injustice that was developed in cases such as Wallhouse, in our respectful submission, both the test of exceptional circumstances and grave injustice, which would otherwise result, have been met. And therefore, this is a case where the court, with the greatest respect, would be enjoined to hear again on the basis that if we're correct, if the merits are correct, then we're dealing with quite an egregious kind of illegality. Then there's another issue of undue delay which has been raised. That issue should not detain the court much longer. Firstly, in respect of former President Zuma, in our respectful submission, there is no valid case to suggest that there was undue delay in the first place, because on the facts, it's very clear that what had happened is that it's common cause that he was appraised of the rule notice 3.3 notice at the beginning of October of the year, and he wrote a letter or caused his attorneys to write a letter to ask for an extension because he was out of the country, and that extension was thankfully granted by the commission. And once he was then able to consult with his attorneys, then he set the matter in motion in a nutshell. So there's no question of undue. But in the unlikely event that it can be found that that period of the couple of weeks until he instituted the recusal application was undue delay, we would say that this is again a matter that falls under that category of cases which were covered in the so-called Gijima principle, which was also confirmed in ASLA, where undue delay ought not to be allowed to cure an illegality. So, and that's what we say. Well, as far as President Mbeki is concerned, he obviously made suggestions that he was supporting our recusal application, and therefore, if our recusal application, was not tainted by undue delay, then it is doubtful my nature will speak. Then I will then go to the issue of the Rule 53.1 application. This is a very important point, particularly for my applicant, because the court will remember this is where we insist, to put it mildly, that the allegations around the alleged misconduct, or the coaching allegations of the evidence leader, we submit very strongly that those allegations have not been properly met or denied by the commission. And if necessary, I'll go into that by using Plascon Evans' various rules of evidence, including the fact that there's a duty to speak whenever there are serious allegations against you, which are peculiarly within your own knowledge. Those types of authorities from the rule of evidence, I'm sure the court is familiar with, is what we rely on for this proposition that there has not, in fact, it goes further than saying that there's not been a denial. We go as far as to say, in certain respects, there's actually been an admission of facts. Now, why is that important? It's important because, as we all know, as lawyers, you can't effectively, the only way you can compel someone to discover something is that you must show that it exists in the first place. So if the existence, as it is in our version, is admitted or at best not denied, then the duty springs up immediately, the duty to disclose it. Lastly, on that point, we know that the only reason that the majority did not adjudicate that interlocutory application was on their version of the majority mootness. And that mootness, so that becomes it begs the question. The mootness, according to the majority, only arises because the Section 47 point is good. So we turn that argument around. If the Section 47 argument is not good, which we were submitted, then the mootness reason for not adjudicating the Section 53(1)(b) falls away. And therefore that it will have to be confronted. That then leaves us with the again, I won't go through all the authorities. The court is familiar with the authorities, Helen Suzman Foundation, and those kinds of authorities about the fact that there's a duty on the party in a review application to discover every scrap of paper that may have any relevance to the topic. That it's a very wide duty. I'm quite sure they could not question that proposition. The question, of course, is whether we have passed that threshold. But as to the width of the duties, it is well accepted. I'm sure my learned friends will also accept as such. That then takes us to the issue of the Section 7, which is the main issue that indisputably we're here about. On that issue, justices, Deputy Chief Justice and justices, we say the following. Again, the broad brush is that we obviously, unsurprisingly, align ourselves with the reasoning that is in the minority judgment. So that goes without saying. So I don't have to repeat what is in the minority. But let me just break it down into a few constituent parts. In our respectful submission, that issue is an issue of interpretation. There's no doubt about that. It is, broadly speaking, deals with interpretation of the section, obviously, and interpretation of the plethora of High Court cases that have dealt with that matter, and even in the interpretation, quote-unquote, of the judgment, of the minority judgment, to the extent that we support minority judgment. So let me break that into those constituents. Regarding the interpretation of the statute itself, the submissions we make are the following. Firstly, that section, the purpose of that section has been mischaracterized both by the majority as well as those High Court judgments on which it relies. In some instances, it has been a misreading of those authorities with respect. And I say that with specific reference to Mutata judgment, FUL versus Mutata, which was the judgment of Mlambo JP, as it then was in this division. And we juxtapose that particular judgment with the judgment of Benenge JP in the case of NP versus LP, that was in the Eastern Cape. And then, of course, there's the so-called Mantashe-Memela debate, which we have to deal with, but we say that debate, contrary to what is posed by the other side, is not decisive of the issues. It deals only with one of the issues that the main issues that we raise on interpretation come from the text of the section itself. One is the interpretation of the word judge in that matter, or if you like, the phrase judge of a superior court. Then there is the interpretation of civil proceedings. Are the civil proceedings that are referred to in that matter, do they fit these particular civil proceedings? And that is linked with the main reason why Modiba J found in our favor on this point, in the sense that the court will remember that what she essentially said was that these were essentially recusal proceedings, or akin to normal recusal proceedings, and that in those types of proceedings, then the judge is not even required to be cited in the first place. But secondly, that judge could not escape or be insulated, to use her word, insulated from scrutiny against bias by by Section 47. So that's the second phrase. The third phrase whose interpretation is important in the section is the head of that court. And in our respectful submission, that the head of that court indicates clearly that the section was not intended to deal with retired judges who perform non-judicial functions. That issue of non-judicial functions is going to be important, so I'd like to underline that. That is the purpose of all of this is to make the following points. One, that this section does not apply in this situation. Around the issue of retirement, which I've mentioned, but around the following also very important. If a judge, retired or not retired, doesn't matter for the purposes of the second point, is cited in their non-judicial capacity, nomine officio, as was done in this case, then again, in our respectful submission, that the section doesn't apply. And I would say speaking for the first applicant, because as the court knows, the second applicant joined our cases, that if you go to paragraph 4 of the founding affidavit, you will see that there was a conscious decision to cite the chairperson of the commission in a particular way. And that citation, I'm paraphrasing, goes something like this. The third respondent, I think she is cited, no, it's the first one. She is cited is a retired judge and a former Justice of the High Court. She is cited in her non-judicial capacity as the chairperson of the commission, and then it goes further. And we will strongly submit that that citation alone is a major differentiator, and that's why we say the Memelamentaship doesn't deal with all the issues, because it really deals with the first part, but not with the retirement issue. So those are two separate issues. Now, before I move away from this, I want to say the following. Apropos why, in our respectful submission, the judgments that were relied upon by the majority, either A, were wrongly decided or misinterpreted. And this is something that really occupied our minds as to where is the actual nub. And we've come with this formulation with respect. There is a conflation on the meaning of the terms service, active service or judicial service, rendering a service and performing a judicial function. This is very crucial to this differentiation. How does this manifest itself, that conflation? In the cases where the two things are conflated, there are two cardinal mistakes that are made. One is very cardinal because it manifests itself in the transplantation, cut and paste, to use colloquial language, of a definition of something in one statute whose purpose is one thing, and literally transplanting that into another statute, completely different. You cannot do that. In the modern interpretation, whether you're talking about end-domainy, cool ideas, and all those kinds of cases, the purpose is all important. So the purpose, the context, and the constitutional alignment, so to speak, are crucial in the interpretational exercise. So one of the worst things you can do in breach of that interpretation exercise is to go and mine a definition from something that was meant for something else, and then just plonk it and put it into something else that was meant for another. That's what we regard as the cardinal sin, and that seems to be at the base of this conflict. How does that do? Because what those cases do is to take the word service as used in the Remuneration of Judges Act and put it in the Superior Courts Act, Section 47, and then say, well, because in that act it says that a judicial service includes commissions of inquiry, therefore, ipso facto, in Section 47, it means the same thing. There are two problems with that. Firstly, Section 47 doesn't say anything about judicial service. It refers to, it relates at least to judicial functions, which is a completely different matter altogether. Now, what is wrong with this transportation is that it takes what is really a remuneration statute, something to do with the payment, and elevates it into a constitutional principle. What do we mean by that? The section to do with judicial functions is a matter that deals with what are the core functions of judges. And the court will be familiar with cases such as Heath, the South African personal injury lawyers versus Heath, where the issue of judicial functions was spelled out, and which in our respectful submission deals with sections of the Constitution such as Section 165, Section 176, which talks about active service and when such active service terminates. Contrary to Section 2195 of the Constitution, which really deals with remuneration of judges, actors, auditors general. So what we're saying is that a remuneration statute is now being used to interpret a statute that deals with the protection of judges' extent. That is. Secondly,
so Advocate Mpofu,
yes,
the gong is gone.
I understand. I heard it. If may I just wrap up this point, or unless if there are questions, which maybe I get the point, because I just wanted to highlight something as far as Patrick is concerned.
In 1 minute. In
1 minute, yes. Now, when it comes to the third part, thank you, Deputy Chief. When it comes to the third part, we'll make 3 quick points. The first one is that what we've termed the ultra vires point. There is no world in which it can be justified that a decision taken by, or rather a matter that was heard by a panel of judges or commissioners, whatever, is then decided by one of them. Whether you're talking about a full court or 3 commissioners, and as in this case. And the justifications that have been offered here, quite frankly, do not even withstand the first scrutiny. So the decision would be reviewable on that basis alone, that it was taken by one person when it was heard by the commission itself. 1. 2. When it comes to the issue of actual bias we have two grounds. One is the issue of the misconduct, alleged misconduct that I referred to, and the second one is the issue of what we call the media campaign. The media campaign that was conducted by the former Justice regarding, in particular, Mr. Zuma, where she went and had interviews on the media, more than one at least, about why she found this way or that way in a case where she was sitting. That's not done. There's not even a debate. Everybody knows that that is not done. Doesn't matter how strongly you feel about the judgment. You can't just go to ENCA or 405 and say, no, you know why I found that way. One of the reasons why we protect judges so much against unfair criticism is exactly because they are helpless. They can't, I can go and say all sorts of things about the judge, but the judge is not in a position to say, okay, well, I want my own interview, and that is for a particular reason.
Yeah, I will stop you there.
Yes. In fact, the last point, which is the reasonable apprehension of bias, I'm not going to deal with because, Mr. Thank you. Thank you so much, Decision, for the indulgence.
Thank you very much, Dr. Mpofu.
Mr. Mpofu, I'm interested in the interpretation of Section 47. In particular, if you look at the section it's brought, it does not make a distinction, active judge, bad judge. So why should we then narrow it, only deal with active and exclude a retired judge? Why should it be the case?
Yes. Thank you, Justice Sisi. As a separate point from the citation point, so specifically the retirement issue. Yes. In our respectful submission, Justice Sisi, it is as follows. If you analyze the reasoning of Mbenenga JP, he makes it very clear. Firstly, purpose, we all know, purpose is important. And that's where we say the disconnect happens. The purpose of the section is not, as the other side would suggest, the primary purpose, at least, is not to protect the independence of the judiciary and all those lofty ideals. It might well be that that's one of the purposes. But the primary purpose of this section is to ensure, as was articulated by the DCJ in his previous incarnation, the primary purpose is to ensure the smooth running of the courts. It is to ensure that there's not chaos, where a judge is allocated by the head of court, and then it turns out that he has to go or she has to go and appear in some matter. So that's the in our respectful submission, the primary purpose is less ambitious than all these issues. That is not to say those issues are not important. Remember, the issues of the independence of the judiciary are sufficiently protected by contempt laws, by immunity laws, and so on. The narrow purpose of this particular section is to ensure that the judiciary runs smoothly. Now, if you accept that for a minute, Justice, then it will follow that unless, and this was a very important point made by Justice Mlambo in the Mutata case, that of course retired judges may sometimes be called upon to perform judicial functions. In that case, they are definitely covered. We accept that. But that must be distinguished from retired judges who are performing non-judicial functions. Because when they are performing non-judicial functions, Section 47 is not intended to protect them. And this formulation was made very clear by Justice Mlambo in the Mutata case. Sorry. That's case number. We didn't upload these cases, so we'll for my colleagues in the bundle, it's page 761 onwards. But this is what Judge Mlambo said in paragraph 23 of Mutata, apropos this distinction I'm making. And what he was saying, he was commenting on the Mbenenga JP formulation, basically to say it's not a blanket thing of are you retired or not retired. It's a question of what are you actually doing, which we agree with. And he said, at paragraph 22, at the outset, I point out that the absence of both the old and new sections of a distinction between judges still in active service and retired judges is not insignificant. Perhaps the most obvious reason is that judges' appointment is a lifetime appointment. It subsists even during the time when the judge is retired. However, for a more fundamental reason of the statement, that retired judges no longer feature in the running of the courts, which is the important thing, must be qualified as I do below. He went on to say, we know that there are judges who retire, but who continue to feature in judicial functions and activities. Very, very important. In other words, the judges who might retire, but are not just sitting in farming somewhere, but are called upon to continue to perform judicial functions. And this is to finalize the part-head matters seized with by importantly retired judges appointed to undertake judicial activities despite being retired. And then he goes on. And then he said, retired judges who are called to act from time to time or to finalize part-head matters fall within the ambit of the above-mentioned administration in that the head of the court retains supervisory authority over retired judges. This is the most crucial point. Those judges, retired or whatever, once they are called back, the head of the court retains supervisory authority, and therefore they are obviously hit by the section. And then I'll jump to paragraph 24, and where the learned judge said, judges who are retired but who continue to either perform judicial functions when called upon to do so by the minister, in line with T, have been appointed to perform the other function as provided by the section. So we agree with that formulation. Where we part ways with the Mlambo JP, as he then was, is when he then, from that point, he then commits what we call the cardinal mistake of conflating judicial functions with service, as in the Remuneration Act. That, we, in our respectful submission, actually counteracts the excellent distinction that he made between a retired judge who is called upon judicial and then any other. And then to bring it home to this case, what we're saying is that the retired judge in this case, was not called upon to perform a judicial function. In fact, she was called upon to discharge an administrative function, advisory to the president, an executive function, which is certainly not.
The commission, is it not called a judicial commission?
Yeah.
So,
Yes.
and the judge, what is the judge supposed to be doing?
Yes. Thank you. No, there's no such thing. You see, the thing about judicial commission is just talk. There's no such thing as a judicial commission of inquiry. If you go to section 84 to F of the Constitution, it says that the president is empowered to appoint commissions of inquiry. So just because in our everyday language we say it's a judicial commission of inquiry does not make it such. It doesn't make this commission of inquiry a judicial commission more than the TRC was a religious commission of inquiry because it was chaired by a priest. So those adjectives that are used in qualifying the commission of inquiry are merely, as I say, just everyday language. Strictly speaking, Justice Mhlanga, a commission of inquiry is a commission of inquiry. And therefore, and to illustrate that point, Justice Mhlanga, let's take three commissions, some of the well-known ones. I've already mentioned the TRC, and then there was the all-important Muarane Commission, which brought us the PKTT and all the things that have subsequently happened. And then there's this commission, or let's take either the so-called Zondo Commission or this one. Those three commissions, Justice Mhlanga, are commissions of inquiry in the same way. They were appointed by the president in terms of section 84. And it cannot be that simply because one of them is chaired by a judge, then there are certain protections which would not apply to Archbishop Tutu or to Muarane SC when they are doing exactly the same thing, appointed by exactly the same person to do exactly the same job. So that's a distinction that is just artificial with respect.
Still on this provision,
Yes.
It says no civil proceedings by way of summons or notice of motion may be instituted against the judge. A review, what is a review? Is it not a civil proceeding?
Yes, it is. Of course it is.
So why would it be excluded from this provision?
Yes. Now, that's a separate point. Firstly, we deal with the issue of the judge. Is the person a judge or not, which you and I have just exchanged. So if we're good on that, then it falls away. But if we're not, then on the point of civil proceeding, we align ourselves fully, as I've indicated, with the reasoning of Justice Mudiba, who says, in a nutshell, Justice, that form cannot prevail over substance. In substance, what we have here is nothing different from a recusal application. The only difference really is this. If it was in court and I wanted Justice Mhlanga to recuse yourself, I would make that application to yourself with respect, Justice Mhlanga, sitting in court. If you found against me, I would then appeal. At no point am I required to cite the judge that is being recused. What happens here is that for technical reasons, which are not important, the recusal application is now brought in the administrative body. And when you can't appeal, there's no appeal in that. So if you are aggrieved by that, your remedy is to review, which is what we have done. So why would, she argues, Justice Mudiba, why would that in substance then be different? And suddenly the one is regarded as falling under Section 47, but the other situation, which is exactly the same, is not. So that's the first. The second is that she says that the difference between the appeal and review in this particular context is neither here nor there. The point of the matter is that the requirement, this is now me speaking, the requirement to cite a chairperson of an administrative body, as you know, Justice Mhlanga, comes from Rule 53. Remember, Rule 53 says when you are citing a body, whatever body, the transport board, you cite the chairperson of that body. So as a representative of that body, here it happens to be the chairperson of this commission who is cited in that capacity. Very important. That's the nomine officio argument. Not being cited as a judge, not being cited even as the decision maker, not even being cited as the person who is supposed to recuse herself and all that, but purely on the basis that a decision of the body that she is chairing is being challenged in court. So why would you now suddenly say that, to go back to my previous example, if I was challenging the decision of Muarane SC as chairperson, I could just do it. But when I'm challenging the decision of another chairperson in terms of rule, I must suddenly something. So that's another decision.
At this stage, my last one, I just want to, it's an observation. If one looks at the section, as I said initially, it's broad.
Yes,
and you seem to be seeking to narrow the provision. And I'm not sure whether we can do that on our own, or aren't we now going to be moving to the realm of legislating if we do that? That's my last one for now.
Yes, thank you. Well, in my respectful submission, you'll be doing that if you do the opposite. You'll be actually widening the section much wider. Remember what I said about this primary purpose. It should never be widened beyond its primary purpose to now suddenly become the one big protection mechanism for the judiciary outside of contempt proceedings, outside of all the... Its purpose in that context, Justice Mhlanga, is indeed narrower. And for an example, if you go to Section 176, I think, of the Constitution. That section, 176(2), it makes a clear distinction between, we all know, and again, this is another colloquialism, that the appointment to a judge is a judge for life. No quibble with that. And that is why, for the purposes of remuneration, that has to be made clear in the Remuneration of Judges Act. So what the Remuneration of Judges Act does, Justice Khampepe, is to say, let's call it's a deeming provision. So if a judge, retired, is appointed to chair a commission, that act basically says they're not going to get any extra pay or remuneration like I or my other learned friends sitting here would, because that's deemed for the purposes of that act to be still a service, continuing with the service. That's fine. We all know that's how it works. But that doesn't mean that the judicial office itself survives retirement. It doesn't. And the proof of that is it's 176(2), which says a constitutional court judge, I'm starting from 1. A constitutional court judge holds the office for a non-renewable term of 12 years or until she attains the age of 70, whichever occurs first, and so on. And then 2, which is the important one. Other judges hold office until they are discharged from active service in terms of in fact, so what that means is that other judges hold the office in the broader sense until the date of their retirement, right? Now, that makes it very clear. We're now dealing here with the question of the judicial office itself. If you go to 2195, it says something else. It says the remuneration of these offices, and then it lists them, will be dealt with. 2195, you'll find, it says, Justice national legislation must establish frameworks for determining the salaries, allowances, and benefits of judges, the public protector, the auditor general, and members of any commission provided for in this constitution. And I dare say that the commission, much as I would have wanted to take advantage, but I don't I don't submit that was meant, this type of commission. I think they meant like a commission for gender equality and so on, including the broadcasting authority, that's the CASA, referred to in section. So all I'm saying is that we can have the same constitution, we mustn't conflate the remuneration matters or a statute that meant to regulate remuneration matters with a statute that is meant to regulate something. And that's the danger, with the greatest respect, with this, what I've called the cardinal sin. The definition section of a statute is not a dictionary. So you can't just say, okay, well, it's defined here as this, and therefore forever, amen, it will mean that. Because that definition section was meant for that particular purpose, particular context, all the issues set in Cool Ideas, and in paragraph 18 of Domain in particular, says that when you're doing this, the modern form of interpretation, you must emphasize the purpose, context, text.
Thank you, CJ.
Advocate Mpofu, just a quick one.
Yes,
to clarify. You're saying chairing a commission does not come under the ambit of Section 47.
Yes.
So a judge who is in active service, who has not retired, who chairs a commission, also does not enjoy Section 47.
Is not performing a judicial function, 100%. That's why
who does the same thing?
Absolutely.
Okay.
Yes, absolutely. Just
no, I wanted that. I don't want you to explain.
No, thank you. Thank you. No, that's why you remember when I said this, I said when we deal with this, whether the judge is retired or not retired, the point is that they are not performing a judicial function.
Yes.
And that you will find in Heath in particular. In Heath, they make the specific example. They say when a judge is chairing a commission of inquiry, they are doing an executive job. I'm putting it in my own language broadly. But they're certainly not performing a judicial function. That's one thing. Otherwise, separation of powers, all the issues that were raised in Heath would go away. In Amabungane, in all those kinds of cases, the same thing, where there was a so-called designated judge. There's no doubt that that judge is a judge, but whether retired or not retired, but they are not performing a judicial function. Because a judicial function and an executive function are two different kettle of fish.
So the same judge who is still in active service, who chairs a commission, and you ask for that judge's recusal, and the judge refuses, that decision will be subject to review, not appeal.
Absolutely.
Which is what you argued earlier, to say in an ordinary matter, where you ask the judge to recuse himself or herself, and he says, no, you appeal it. You appeal when he's hearing a matter, not a commission.
Understand the question, Justice.
That's what you said, isn't it?
That's what I said, but what I said earlier must not be forgotten. Remember, when I was talking about the definitions, I said the first definition we must go for is judge. Is somebody sitting in the chairing a judicial inquiry or some investigation?
I don't want you to go.
No,
I just want to explain what my question is.
No, but it's very important, Justice, please.
Okay.
It's important to make this distinction. Because the mistake, with the greatest respect, that you make is to say, well, it's a judge. But I've already said that person is not a judge for the purposes of chairing that could be judge or someone, but they're not performing a judicial function. The fact that they have a security of tenure for the rest of their lives as judges is known. At that point, you are not citing them as a judge within the meaning of Section 47.
Thank you.
Really
Good morning, Mr. Mpofu. I have a question that follows on Justice Mhlanhla's question on Section 47.
Yes, Justice.
But also my primary difficulty is with an antecedent process of direct appeal to this court. So to make things flow smoothly, I'm starting with Section 47. That's backwards, but you understand why I'm doing that. Now, I'm going to give you a hypothesis, and it's a hypothesis which is not too far from actually happening. Let's say I'm on long leave now until the end of the year, and then I retire.
Right.
So you got a period from now until, say, December 31, long leave, active service, and then retirement. I'm also on the Judicial Conduct Committee. Now I sit in a matter, let's say a Section 17 matter where the judge may be cautioned or not discharged, but cautioned or fined or so on. I said as a member of the Judicial Conduct Commission, you accept that if a matter arises in the course of those proceedings in the JCC, where there's some suggestion of impropriety, let's call it bias, whether actual or perceived. Some things that happen that get one of the parties thinking this may be a ground for recusal, but they're not sure yet. Then I retire, and that matter is parted, and I continue as a matter of the judicial, as a member of the Judicial Conduct Commission. But I'm now retired, and then more evidence comes to the fore, and the party is now absolutely convinced that there are grounds for a recusal application. Does that mean, on your argument, that up until December 31, if you bring a recusal application, we now facts at your disposal, you would need the consent of the head of the court, of the Chief Justice, because I'm a member of this court, and after that you don't need it?
That argument actually shows the absurdity of the counter argument. Thank you, Justice Kachit. Let me answer it like this. If that were the case, really imagine that. If exactly you're doing the very same thing, but merely by the fact that at a certain point you have retired, suddenly you now require a permission. That would actually be an absurdity, because it would in one way mean that when you were a judge in the proper sense of the word, one did not need, and you are sitting, and I know I'm a just example, but let's say if you're a judge sitting doing a proper judicial function, then I don't need to do anything. But once you retire, I suddenly have to get back. Come back to your specific example. The answer is still no, and it is no for the following reason. Whether you are retired or are not retired at a particular point, it's not about that. It's about the function. That's really, and that's where the nub of the confusion really arises. Are you performing a judicial function, yes or no? Retired or not retired? If you are, then the section, as was eloquently distinguished by Justice Mlambo. Judge Mbenenge says that this provision is for the smooth running of the courts, and that is why the head of the court is the one who must give the consent. It is not it's not even a jurisdiction provision, as was wrongly suggested by the majority. It is because the jurisdiction of the High Court, with respect, is spelled out in Section 169 of the Constitution, and that jurisdiction is either there or it's not there. And so the jurisdiction of the High Court is there. What Section 47 does is something less majestic than confer a jurisdiction or otherwise. It simply regulates the functioning of it. Which is not an unimportant thing. We're not trivializing that function, but we're saying it must not be conflated with the broader protections of the judiciary, which we all support.
Thank you. Now, can I just say that, sorry, were you finished, Mr. Mpofu?
No, I was, no, it's my fault, but I just wanted to make a certain point, if you allow me, Justice. This distinction, ironically, is made by Justice Khampepe herself. If I may just make the note of this, Justice. At 001-274, Justice Khampepe, who now comes, before the clever lawyers came to bring this Section 47 point, she herself stated in January, this point was brought in March this year. In January, this is what she said, to show that she understood the distinction. Look at paragraph 38 and 39. She says, in giving her, Mpofu SC, who appeared for the former President Zuma, sought to downplay the judicial presumption of impartiality by arguing that I'm simply the chairperson of a tribunal and not sitting as a judge. I disagree. I've been appointed by the President through Section 82F, presidential powers, to chair a Judicial Commission of Inquiry. Address that with Justice. The word judicial really doesn't add it. I've been appointed precisely because of my oath of office and because I'm a judge, albeit presently retired. It is my considered view that Mpofu SC's contention is devoid of substance. The presumption of judicial impartiality remains in my present role as chairperson of the commission, as I've said, as the one not easy to dislodge. Now, she may be right or wrong about the impartiality. I'm just addressing your question. Now, here's the kicker. Paragraph 39. She says, this is not to say that I fulfill judicial functions in my present position. Commissions of inquiry are not courts of law. This commission is an investigatory body tasked with investigating the matters set out in these terms of reference. Commissions will ultimately report to the President, which means they are executive instruments, not judicial ones. On the outcome of those investigations, the commission may make a recommendation to the President, but it will be up to the President on whether to implement such recommendations and so on. Now, here she's explaining our case, that although I may have been appointed because of my oath of office and the judicial impartiality, but I'm not performing a judicial function. Why? Because this is not a court. There's no Section 47 which can transform a commission of inquiry into a court. That would be a travesty of Justice Pan's excuse. Because what she's saying there in paragraph 39 is exactly what's correct, as I say, until such time. Or paragraph, I'm asked to read paragraph 40. She says at 40, this commission does not function as an adversarial body, and the proceedings before it must not be confused with litigious court-based proceedings with winners and losers. Correct. All I can say is we agree. We agree that she's not performing a judicial function, and if she's not performing a judicial function, whether she's paid or not is another matter, but she's not performing judicial function, and is not performing Section 47, that cannot apply. And as I say, subsequently, some clever lawyering came in, and now the position was that, no, she was now judicial function of Section 47.
Yes, thank you.
Thank you.
With great respect to my colleague, she's a formidable judge, but that's just an opinion.
Of course.
It's this court to decide. It's no different than the president coming here and saying, if I had known now what I had known then, I wouldn't have opposed X, Y, Z. It's just an opinion.
Yeah, well,
I say that with respect. But let me move on. You see, Mr. Mpofu, I must say that there are strong arguments, and you've presented some of them very ably, as to why this section could be interpreted both ways. But I've got an anterior problem, antecedent problem. It's this. There is an appeal now pending in the Mantashe case, which is directly relied upon by the majority in this case, before the SCA. It will be heard this year. You filed conditional applications for leave to appeal. You filed an application for leave to appeal in this court. You filed conditional applications for leave to appeal in the SCA. Now, why should the SCA not on an expedited basis hear those cases and you join the other case, because they're the same principles?
Yes.
And I'll tell you why I ask this. If, as I think the Kalata group, the sixth respondent makes the point, if you're going to ask for a case management in the SCA, for the president or whoever judge is designated, to expedite this hearing because of the urgency of, then this matter could conceivably still come before this court before the end of the year from the SCA. You see, in this court, I see you look skeptical, but you see in this court, we've got to be careful because, as you know, litigants come here in the future and say, but you did it in the Zuma matter, you heard a direct appeal, while there are appeal pending on the very, very same issues. So it does concern us. We, as you know, prefer to hear the views of not only the High Court, but also of the SCA.
Thank you, Justice Mchit. Forgive me for the skepticism is very well justified and based on experience. The chances of the matter coming here within the commission being finalized in December on the extended are very narrow indeed. But
no faith in us or in the SCA?
well, it depends where I'm standing. Right now, I'll say the SCA. Honestly, that's not Justice Mchit. To take that route, firstly, let me say this. The only reason why we do the conditional application, as the court knows, is because it's just a question of time. Because if you don't do the conditional application and this court rejects the application, then you have missed your 15 days for application within the High Court. So it's really purely a practical reason. That's number two. The burden, let me put it that way, on us to make an intervention application in another matter where that intervention application may or may not succeed in the first place, as opposed to dealing with this concrete matter that is here now before us, is a risk that no party should ask to assume easily. Thirdly, as matters currently stand, the main Mantashe matter, if I call it that, is not being pursued on an expedited basis. And therefore, we cannot very well enforce or put down the throat of those parties expedition. Now, and I accept, Justice Mchit, the reluctance of this court, which we all support, to hear matters as matters of first instance. And that is why I referred this court to paragraph 33 of Ramakasa, where that was done reluctantly as it was, because of the other factors that we have relied on, and in other substance, because I read out those extracts, 16, 7, and we, with the greatest respect, we say those considerations apply with equal force, if not more, in this matter.
Well, lastly then, and relatedly, if you come to us to decide the merits of the review, then you're really coming on a direct access basis.
Yes, thank you. That is why both applicants have specifically asked not just for direct appeal, but also for direct access. Because you're right, in these kinds of situations, as was done in Ramakata, the direct access and the direct appeal was really on both legs. And that is why I referred to what was then done in Ramakata, was to say, because the matter is urgent and it can't wait, it can't go through the whole route of SCA and so on, we are giving you parties, and I remember this because we were given like a week, to supplement your papers if you wish to, and then we'll hear the merits. And my response was that in this particular matter, that would not be necessary, because the matter was extensively pleaded, extensively argued, and in the previous court. And more than that, we now have a bonus of the minority judgment, which has dealt with the merits. So to the extent that one wants wisdom, the wisdom is everywhere. We have the wisdom of the Eastern Cape, the wisdom of the Limpopo court, the wisdom of the Gauteng, the many Gauteng judgments that have been referred to, the wisdom of the Mantashe and Memela. So there's no shortage of wisdom. Even Erasmus says that on the question of retirement, the note of this, Erasmus says that it says there's differences of opinion on this question of retirement, and it cites the FUL case and then the case. So in our respectful submission, this is a case which commends itself for a decision by this court. For an extra reason, Justice Mchit, that these commissions, as we all know, are now proliferate, and these kinds of matters are brought in, day out, because of the Zondo Commission, the Matlanga Commission, and other commissions. And this point is being taken left, right, and center. And it is important that on our respectful submission, what is purely a legal point, which is the interpretation of Section 47, should now be decisively, once and for all.
And do you accept that, lastly, on this point, that direct access is really a higher threshold to cross than
Absolutely.
directly.
We accept that implicitly, that it is a high threshold, but again, we say exceptional circumstances, interest of justice, and the urgency of the matter necessitate in the same way or even more with bigger magnitude than in the Ramakatsa instance, that this case, this type of matter must now be put to bed. Because with the greatest respect, Justice Majid, to expect these parties who were the, shall we say, it would be almost like condoning the breach of the rule against piecemeal litigation. Because, as we all know, and we've cited the authority, courts, it is exactly because of the question you're posing to me, Justice Majid, that courts are told day in and day out that even if you find on a technical basis, on jurisdiction or whatever, you must still deal with the merits. Why? So that when we come here, we wouldn't be faced with a situation, as imagine if there was no minority judgment. All we would be, this court, it would be unfair on this court. All this court would be armed with would have been this interpretation of Section 47. And let's assume the court would then agree with us. It would then have to remit the matter, even worse than the SAA, remit it to the High Court, go to the SAA, and then come back here in 3 or 4 years' time. On these facts, there's simply no...
Ms. Peterfin-Jones and Mr. Butlander will argue that you started all of this by bringing application from midstream.
Yes, well, no, we didn't start all of this. The person who started this was the chairperson who remember, for this leg, we are assuming that our allegations are true. So we had a chairperson who, knowing that she had taken part in the decisions in the TRC and in the NPA, persisted unreasonably and illegally, if I may put it that strongly, to sit. She started. We have a chairperson who was told by the president, who appointed her, that if I had known this, I wouldn't have appointed you, please go. She didn't go. She started. We have a chairperson who has insisted on sitting in a position where she's, quite frankly, unwelcome, and her findings are bound to be found illegal. Because anybody, whether she finds for or against a person, is going to simply say, well, the person who appointed you said they don't want your advice. Remember, commissions of inquiry are advisors. They're in the same position as a DG. So you can't force yourself, just like me. If I go to a client and I say, the client says, please advise me on this, Mr. Mpofu, and then I give the advice, and one day they say, I no longer want your advice. But I can't say, no, you want my advice. I'm going to give it to you whether you like it or not.
Yeah, I just want to say on this, this is the merits. I'll leave my colleagues to see with me. It just seems to me that when you are asked to do a commission of inquiry on one aspect, and one aspect only, is to investigate whether these allegations of political interference in the commission is true. I fail to see, prima facie, you can persuade me otherwise, how that links to your work on the TRC Amnesty Committee and in the
Yes.
that will be my last question.
Thank you, Justice Majid. Let me assist then very quickly. If Justice Majid, let me put it this way. On the facts of this case, you have a person who sat in the Amnesty Committee of the TRC to decide who should be prosecuted and who should not be prosecuted. That person, and my learned friend Mr. Manecha will refer you to the specific findings which are signed, Justice Khampepe. They have to do with the PEPCO 3 and a gentleman family of Mutasi. Those people are members of the Talata group. So you have the same person who denied the amnesty to make those people prosecutable. After that, she then moves to the NPA. In the NPA, what does she do? She works for something called the HRIU, whose function, according to Justice Saldanha, is to investigate the prosecution or non-prosecution of those people that she denied investigation. That alone was illegal, if you ask me. But then it doesn't stop there. Now, this is triple bias, if there's such a thing. She now sits to judge whether the NPA and the Amnesty Commission, that chain, was suffering from political interference. And that political interference would have been, if it was there, meted out to her, because she was the Deputy National Director of Public Prosecutions. How on earth can that person, of all the judges in this country, be the one to investigate this? I can tell you now, Justice Majid, that there are maybe let's say two for argument's sake, two people who should not be chairing that commission. One of them is Justice Saldanha, and the other one is Justice. Why? Because Justice Saldanha was called recently as a witness in this commission to deal with exactly this point of when he was sitting with Justice Khampepe in the HRIU, whether they influenced or not. Mr. Nguka, who was their boss, both of them, has been called as a witness. So that means that Justice Khampepe is a competent and compellable witness in the commission that she's chairing. What is that? That can never be countenanced in a
Thank you,
democracy.
Deputy Chair.
Thank you, Mr. Mpofu.
Justice Khampepe.
Mr. Mpofu, it's common cause that we're not dealing with a constitutional challenge to Section 47.
Absolutely. No.
But rather its proper interpretation.
Correct.
You point out that both the majority and the minority judgments in the High Court did not address the interpretation of Section 47. Well, your heads of argument say that. But anyway, that's not the heart of my question. What you're really saying is that we should properly interpret Section 47.
Yes, the minority did on our
Based on that, we need to start with the plain language of the section and have regard to both the context and the purpose. You point out that the purpose of Section 47 is to ensure the smooth functioning of the courts. Is that right? And
what I call the primary.
Sorry?
What I call the primary purpose.
The primary purpose.
Yes.
And we have to then interpret it in accordance with that purpose. Now, if one has regard to the structure of 47, it's broken up into two parts.
Yes.
The first part provides for the consent of the head of court, correct?
Yes.
The second part deals with ensuring that that there's consultation with the head of court when a judge's attendance might be required in proceedings.
Yes,
It says so expressly.
for 7.2.
47.2, it must be determined in consultation with the relevant head of court. That is when a judge is required to attend court. It would seem to me that 47.2 is primarily concerned about the smooth functioning of the court, because you would need to consult with the head of the court in order to ensure that the court is not disrupted when that judge is required to attend proceedings.
Correct.
So having regard to the basic canons of interpretation that we all agree upon, why was there a need to have 47.1 when the primary purpose of Section 47 was to ensure the smooth functioning of the court, and 47.2 does that? All that the legislature would have been required to do was simply say, when a judge is sued, then the head of court must be consulted when that judge is required to attend court. If we read 47 on the consent part in accordance with your understanding of purpose, then we give it a meaning that's wholly different from the purpose you say, and therefore it must raise in the sharpest terms whether the purpose you ascribe to the section is consistent with the terms of the section.
Yes, thank you, Justice Khampepe. Understand that. The first answer is this: the purpose of Section 47 is the purpose of Section. It doesn't have one purpose in subsection 1 and another purpose in subsection as such. I accept that, as you correctly point out, that the two subsections deal with two separate situations. But that's not a question of purpose and context. The purpose, the context, the constitutional architecture of the section remains. And with the greatest respect, that purpose is even traceable to the in Section 8 of the record, which deals with. Now, we say the direct answer to this, that those two purposes or those two subsections serve, which is smooth running. And we agree in that respect with Justice Mbeki, and we agree in that with Justice Mlambo, up to the point that I said we put away this budget service, that section applies to retired judges who are called upon from time to time. Why? Why does it apply to them when they do that and not when they are farming somewhere? It is because the purpose is regulation of the minute they get involved in that business of the smooth running of the court.
I understand that, and sorry
Yes.
to interrupt you, but my difficulty is that if that's the purpose, then a reframed 47.2 would achieve the purpose. There is no need to obtain the consent of the judge president. The mere issuing of a summons is not going to disrupt the functioning of the court. Surely a summons that's issued today in the High Court will only get to trial in 3 years' time. The issuing of that summons can't disrupt the functioning of the court. Why is the consent of the head of court necessary if, according to you, it's to avoid the disruption of the court's functioning?
Thank you, Justice. The point I'm making is that both sections deal with the permission head of. The other one really is.
They don't deal with permission. The first one deals with permission. The other one is really a consultation so that you negotiate a time.
Well,
But I mean, the first one is a condition precedent, not so.
fair enough. Fair enough. But the point I'm saying is that both. I'm not saying consultation and consent are the same thing. I'm saying both deal with the smooth running of both the consent requirement and the consultation. That I accept that they deal with. I'm saying both topics have to do with the smooth running of the. And if you look at where it says where the issuing of a summons or subpoena against a judge to appear in civil action has been consented to. In other words, when one has been dealt with, the date upon which such judge must attend must be determined. So this is just about now the date, the practical arrangement of whether having received this consent to further protect, if you like, the smooth running of the court. You can't simply say, oh well, the head of court gave me permission, so I'm now going to just somewhere call that judge on any day that I like. You must still to protect the smooth running of the station.
Thanks, Mr. Mpofu. I take a different view because I see them doing different things, but
No, they certainly do.
We need not exhaust them because, as I point out, I fail to see how the issuing of a summons can affect the smooth running of a court. It may potentially affect that when you have to come to court. But let's move on to the second concern I have, and it's this: the capacity in which the question of capacity, according to you, is whether you were a judge in active service or you were acting at the time having been discharged, where consent is required. Correct? I mean, if you're discharged, and you're asked to come back and act, then
Yes, that's part of it, Justice Khampepe, and the citation capacity in which you were cited. But I'll go along with it.
But can I just get the capacity in which you're cited?
Yes.
Are you saying that a judge who's in active service and who's sued for defamation, let's say, in respect of a private matter that has nothing to do with judicial proceedings in which that judge presided, Section 47 would kick in, not so? I mean, if today you want to sue a High Court judge for having defamed you in a public place,
Yes.
you would need to comply with 47, not so?
An active judge.
Yeah.
Judge in active. Yes.
Judges, you would need to.
Yes, because
So your-
but
your-
that's for a different reason.
Yeah, but your capacity, which in relation to the lawsuit, doesn't really matter because you were acting in your private capacity when you defamed somebody, but you're being sued, and the person who's being sued is a judge. You're not being sued in your capacity as a judge, correct?
Yes, no, that's correct.
So you agree. So my question is this: does it not create an anomaly that if I'm discharged from active service and I do something like that, on your interpretation, Section 47 does not apply? If I'm asked to come and act for 6 months, but I did this last year, for example, they decide this is the time to issue summons, then they need to get the permission of the head of court.
Yes.
But they wouldn't need to get it if I'm a judge, but not acting. Doesn't that create sort of an absurdity that you're
Absolutely
dealing with someone who's no longer a judge, but is only a judge temporarily for a limited purpose, but then you need to get the permission of the head of court, even when it might not disrupt, because the head of court might say, well, The person's acting for 3 months. There's no way this case is going to come to court within 3 months, and if the purpose is not to disrupt, well, what's the point? What's the purpose then of 47 if it's only that?
Thank you very much for the question, Justice. Yes, when you defame me somewhere, then there are two distinct. One is that you are not performing judicial, and that when you are acting, the minute you come from that village to go and act, you are performing judicial. So that's the crucial. Secondly,
Understanding what the difference is, because the lawsuit relates to when you were in the village, not so.
Yes.
And when you were in the village, you were a judge. You were not performing your duties as a judge, but you were a judge in active service.
Yes.
And 47, we agreed, applies there.
It applies for a completely unrelated reason. Explain, that's what I was coming to. The second reason is this, and Mlambo JP made this point, and in Sola, which is the original case of Moape JP, the point was made. Section 47 does not only apply when you are performing judicial function, it also applied when you are being sued personally. So in your example of the village, I would be suing that judge personally. Here, none of those two gateway provisions apply, because the judge, the former judge that is being cited here, is neither being sued for judicial functions, nor is she being sued personally. She's being sued in her capacity in a third category called the Chairperson Administrative Body, NO, nomine fictio. When I'm suing your judge in the village, I will not say NO, because that is a different category altogether. And that's where part of confusion actually is caused by this of saying, well, if it can go, which is really the nub of the question, if it can go beyond judicial function, then what's your problem? But the question is, in which direction is it going? If it's going in the direction of personal suit, yes. But if it's in the direction of a non-judicial function and a non-personal function, which is where we are, then, oh yes. I've already apologized to the DCJ. We had promised to upload the finding of the JCC, which we did this morning, that we refer to in our heads. But and we accept, before anybody says that this is not binding precedent. It's being presented just as much as we would have presented it, albeit it was done by Justice Jafta and so on, but they were not performing judicial functions. But this is what they say, paragraph 2. A careful reading of the language, or the case lines is 006.1-122. They say, a careful reading of the language of Section 177 of the Constitution in the context of Section 174 and 176, that's the point I made earlier to Justice Mlambo, reveals that the President appoints judges to the judicial office in all superior courts. And it goes with 176 and puts an emphasis on 176 that I did put. And then it says, judges of other courts, including the SCA, hold office until discharged from acting service in terms of legislation. Upon this discharge, the judges vacate office and retire. Very important. This is how Section 176 of the Constitution was interpreted in Siriti. The fact that a judge who vacates office in this manner retains the status of a judge does not mean that he or she continues to hold office. There is a clear distinction between that status and judicial office. This distinction was also clarified in Siriti. The status attached to the incumbent of judicial office, and when he or she vacates the office, he or she retains that status even while in retirement. But that status does not mean that the judge continues to hold office. On the contrary, he or she becomes a judge without office from the moment he or she vacates the office in terms of Section 176. As a result, he or she cannot exercise judicial power or function in the head, or perform judicial functions or themselves, unless reappointed back into office for a temporary period. But if he or she is guilty of gross misconduct or suffers from incapacity or is grossly incompetent, he or she would not qualify for reappointment, even if he or she would otherwise have been eligible. That second part obviously related. The crux of what these justices were saying, all being non-judicial, was that that distinction has to be respected. As I say, again, in everyday language, a judge is a judge for life, we all know that. But they make the crucial distinction between that, for the purposes of payment and all that, and purposes of holding judicial.
But then finally, Mr. Mpofu, you're saying then we must interpret 47 to read that no civil proceedings by way of summons or notice of motion may be instituted against any judge of a superior court who holds office at the time, something to that effect, because we both agree that a judge who is retired is still a judge,
of course,
and would, on a plain reading of the section, fit into it. And one would have to qualify it then by saying any judge who holds office at the time, either permanently or in an acting capacity, something like that.
Well, Justice Khampepe, I'm not asking for a miracle. I'm asking for you to do exactly what Justice Mlambo did with Tata, which is to say, when he said, once retired judges are called back, then the section up. That's really all we're asking. And that, in simple legal language, simply means that it's not any old retired judge who's doing whatever is caught by the section. And Justice J.P. Mbenenge said exactly the same thing. And with the greatest respect, Justice Mlambo, in that case, did not differ with the formulation of Justice Mbenenge. He merely qualified it, and with respect correctly, to say that to the extent that it doesn't apply, in other words, he was turning even the Mbeki JP formulation to say you can't simply say, well, if you are retired, no, that can't be true. And that's not what we're arguing. Even if you are retired, if you are called back to perform a judicial function, then, so we agree with the qualification made by Mlambo JP, as it then was, of the Mbeki.
Mr. Mpofu, if we look at Section 47.1, it seems to have broad application, and there's a specific exclusion of domestic violence matters.
Yes.
Leaving aside for a moment the purpose of provision, on what textual basis can we exclude from its application any other proceedings against the judge, and where those proceedings originate commission inquiry?
Yes. Firstly, the textual basis is on the use of the word against. The reason why the crafters of that section use the word against must have been, at least, or one of the purposes, to distinguish from situations where you are citing the judge, but the proceedings are not really against that judge. Remember again, and we go back to the Modiba J analogy. When you are applying for a recusal of a judge, now talking in a normal court, you are not exactly bringing anything against that judge. You are bringing an application for fairness, for lack of bias, for impartiality. It's not against that judge. That is why in the High Court you don't have to cite the judge. And even if the judge refuses to give my recusal, when I go to the SCA to then challenge that, I still don't have to cite the judge, because the matter has never been against that. It has been for the protection of impartiality. That's the first textual base. The second textual base, Justice Teron, is that the phrase, the head of that court, it would be an absurdity to the head of that court. What court? For a retired judge sitting in his farm somewhere there and doing their own thing, and then you say the head of that court. As Justice Mlambo said, once that person is retired, excluding the situation of being called to act, they are no longer within the supervisory, I can't remember the actual phraseology, the supervisory jurisdiction or ambit of the head of the. So who would be the head of that court? It would be an absurdity. Actually, that absurdity is playing itself in another. I don't want to let it out of the bag. But it comes this way, Justice Teron. If the person you are suing was a Chief Justice, for example, or a Chief Justice, then who's the head of that court? As I say, it's for the current case, it's not. So that's the second textual base. The third one is the one that Modiba J pointed to, which is that recusal, for the purposes of this section, recusal applications, broadly speaking, are not civil proceedings. And she asked the rhetorical question. Again, this is the thing of applying after legal advice. So she says, if that was the case, then why was it not necessary to do a Section 47 application in the recusal application itself? And the last point which I want to make is this. In the case, again, today I seems to be supporting Mlambo JP's judgments. That's not for opportunistic purposes. But here's an example, Justice. If you go to the case of Corruption Watch and another versus Arms Procurement Commission and others, you will find in that case that the very same Justice Mlambo, who had made the other decisions, did not insist on a Section 47, which he could have done Meramoto, let's assume it was not raised, but let me explain the reason. The reason is found in paragraph 4 of that judgment. This is what Mlambo JP said. The first applicant is Corruption Watch, a non-profit company registered in accordance with the company laws of South Africa. Second applicant is Right to Know campaign, and so on. And here's the part. The first respondent is the Commission. The second respondent is Justice Willie Lehwabe Seriti, NO, nomine officio, who is cited in his capacity as the chairperson of the Commission. That's exactly why we cited this respondent here in the same way. And then he says the third respondent is former Judge President Hendrik Tekiso Musi, NO, who is cited in his capacity as a member of the Commission. The fourth respondent is the Minister of Justice, and so on. And then it goes on. I admit that the issue was not squarely raised in that matter, but I venture to say that the reason why this citation, which is a mirror image of the citation that is used in this case, was not subjected to a Section 47 permission requirement, is exactly the fact that those judges were cited A, nomina officio, and B, in their capacity as chairpersons of a commission, which is the same as this one.
Mr. Mpofu, apart from the minority judgment of Justice Mood, what other authority do you have that these are not civil proceedings for the recusal? Civil proceedings as that phrase is used in Section 47.
Well, the authority is, firstly, even Justice Modiba, who makes this proposition, accepts that in form it is. All she says is that form should not be elevated over substance. So that qualification is very important. So nobody, neither me or Justice Modiba, even West, would come and say, and that's why I answered the question candidly to Justice Mhlanga. Are review proceedings civil proceedings without more? Yes, of course they are. Everyone knows that. The point is, in the context of this is are these proceedings in substance, not recusal proceedings like any other recusal proceedings? That's the point that really Justice Mutiba is making. I'm quite sure she's not making the absurd point that putting a notice of motion and going into court to do review application is suddenly not a civil process. But if it is it against? And that's the point. And we venture to say, no, it's not against anyone. And,
So we can accept that there are civil proceedings as envisaged in Section 47?
No,
We can't?
No, we can accept that
I'm confused, Mr. Mpofu.
Well,
either
shouldn't be.
the argument is that they are not civil proceedings as envisaged in 47, or they are.
Put it out. There is such a thing
Because
as...
against comes afterwards.
Yes. But
So they could be civil proceedings, but on your argument, they are not against the judge, if I follow you.
that's not what I'm saying.
Or
I'm
you're saying they're not civil proceedings and they're not against the judge.
I'm not saying that. I'm saying they are not civil proceedings for the purposes of Section 47. That's all that Mutiba J found. That recusal
Now,
proceedings...
this is my question.
Yes.
If your submission is that they are not civil proceedings as envisaged in
In
Section
Section
47,
yes.
apart from the judgment of Mutiba J, where is your authority for that proposition?
Well, the authority, as I've said earlier, is based on common knowledge that all the judges sitting here have, that in recusal proceedings, you do not have to cite the judge. And that's the point that she makes, number one. Number two, that she says the technicality, and you may or may not agree that it's a technicality, but she says that the technicality that if you are aggrieved by that decision, excuse me, in the case of a judge sitting in court, you would appeal in the SCA, and in this case you would review them. Is neither here nor there. That's what she says, and we agree with that. So she's not saying, as I say, it would be absurd for her to hear, and I'm sure she's not saying that bringing review proceedings is not simpliciter civil proceeding. That's not the question you are required to ask. The question you are required to ask is like saying a judge. Is she a judge? Yes, she's a judge. But is she a judge for the purposes of Section 47, as envisaged in Section 47 with the purpose? Because we can't put aside the purpose with the purpose and all that. And it might well be that for a particular purpose, as explained by the JCC, the person is a judge for life. We all accept that. The question is whether once they are retired and they are doing something unrelated to judicial function, they are hit by the section.
Addressing your argument, Mr. Did the chairperson have to decide the recusal application at the commissioners, or does the rules of the commission's rules allow her to have decided that herself?
Thank you. I did address this in my 30 minutes. I called it the ultra-virus point, but maybe I should just call it the improperly constituted voter. It's the same thing. Thank you, Justice Teron. The chairperson cannot have it both ways, with the greatest respect. The chairperson, as I said, is cited as a chairperson of the commission, right? In other words, she's the symbolic representation of the commission, number one. That can never mean that she is now isolated as a human being. And proof of that, Justice Teron, is the fact that when on the 16th of January this year, we went to argue the recusal application, she sat in a panel with the other two commissioners. If she thought this was just about her, what were they doing there? They were...
No, I don't want to interrupt you, Mr. Mpofu, but can you answer my question legally, please? Like with reference to the rules, with reference to the law, was she entitled to make the ruling by herself? We really want to know what perhaps was in her mind. Can you contend and refer us to this rule or
Yes,
this case to say she had the power
I will.
to make that ruling by herself? And it seems to be common cause, and please correct me if I'm wrong, that she decided the application alone. Is that common cause between the parties?
Yes, it is. But unfortunately, the question has to be answered in the manner that we have presented the problem. And it is the following. Let me start with the rules so that we get that out of it. The reliance is put on Rule 3 when the application was brought in terms of Rule 11. And the application is made to the commission, right? And how do we know that? Because we know that because... sorry, if you go to 011672, okay, well, let's take it a step before. You remember that the affidavit of Semenya SC, which we say should be read as pronoun scripto, is purportedly done as an affidavit of the commission in the first place. And so it says there, sorry, I just want to go to, let's start at 746, or 746. Sorry, Justice. 746. Yes, I think this makes it much easier because this is on the pen of Justice Khampepe herself. These are the directives that she gave us in terms of Rule 3.3. No, she says notice in terms of Rule 3.3, Jacob Zuma, that was just a heading because that's her application. Then she says, in response to your letter, 3rd December, requesting that I be recused for reasons outlined in your letter, the Commission deems it fit in the interest of time available for the Commission to discharge its work to consider your client's request through the following directives. So it's the Commission. And then just run to 1.1. Your client is directed to file his application for my recusal to the Commission.
Mr. Mpofu, once again, I don't want to understand the attitude of the Chairperson of the Commission. I want to understand what the rules say and what the law says.
Okay, let's start there. Maybe that will make it easier. The SARFU, the case of SARFU, makes it clear, which we've cited in our heads, that when the recusal of a member of a panel is called for, that panel collectively, individually first, and collectively must make that decision. Why is that so? It is so for a very important reason, Justice Teron. Because we can never be in a situation which we are in now, where neither ourselves nor your esteemed selves know whether the other two commissioners agreed or disagreed with the finding. SARFU says it's not only our rights that are violated, but the rights of the other two commissioners. Because those commissioners have a right themselves to say, if these are the facts, we do not want to sit with you. And that's what SARFU says. SARFU says, so it's not just a question of just sitting there as a collective and taking collective decision. No, it is because the majority of the commission could possibly have upheld our application. So we don't know. The majority is excluded. What kind of procedure how can that in any law, anywhere, be a situation where, let's say it's a panel of 3 judges in a full court, and then you just hear one person, and you don't know what the other 2 judges' view is on the matter. Simply because, even though they sat in the recusal application, let's say it was this panel, and one is asking for a recusal of one of the judges. The rest of the panel, even though the recusal is not directed at them, according to the SARFU, the Constitutional Court precedent in SARFU, is entitled A, to sit for obvious reasons, but B, to decide. And it may decide against that one. That one judge, who is the target of my recusal application, might think that I don't agree with Mr. Mpofu. But if the panel agrees, then we will succeed. In this case, the process was illegal in the sense that the body or the person who took the decision, the commission was improperly constituted, to put it in normal language.
The respondents point to a number of rules
Yes.
of the Commission that allows the Chair to decide interlocutory applications on her.
Yes.
Why is this different? It is an interlocutory application, isn't it?
No, it's not an interlocutory application, with the greatest respect. This application goes to the root of the very existence and composition of this whole business. The terms of reference, remember the terms of reference of the President says, I, President Ramaphosa, hereby constitute something called the Commission. That Commission is made up of Commissioner A, Commissioner B, and Commissioner C. So the thing called the Commission is a collective of those persons. That's the first point. The second, so it's not an interlocutory application with respect. But surely, if that was the case, then why is it that in the other recusal application of Seminya SC, the Commission gave a ruling? It did. And all of a sudden, in this recusal application, it says I. And you can read it through. It no longer says the Commission finds this or that. It's now I.
I'm still trying to understand why it's not an interlocutory application. What application would... Let me ask 2 questions together.
Yes.
Do you agree that there are interlocutory applications that the Chair can decide on?
Of course, in terms of the rules.
Why was this not an interlocution? It's brought during the life of the Commission as an application.
No. Not every application that is brought during the life of proceedings is an interlocutory application. Interlocutory, in this sense, is in the okay, that's another section 18. I won't go there. This application is fatal and abortive to the very existence of the foundation of the Commission as presently constituted, or as will ever be constituted.
That on its own wouldn't make it that it doesn't qualify as interlocutory. How many other interlocutory applications are not fatal to main proceedings, but they still in their nature are interlocutory proceedings?
Yes, interlocutory proceedings, as said in Rule 611, if we want to go to the specifics. Rule 611 of the Rules of Court tells us what interlocutory proceedings are, and those are the proceedings that are brought in the short form, not in the normal long form application. And because they are ancillary to in other words, they're not totally defeating to the cause. Remember, the causa of the actual proceedings stands. But to bring interlocutory application, like our Rule 53(1)(b) application, that's an interlocutory application. Why? Because it simply says you must discover in the main cause. But if we were bringing an application that says you are in the wrong court, you should have sued me in Durban, you are now suing me in Cape Town, that cannot be described as an interlocutory application. That's an application that goes to the root of the very existence of that causa. So, but if I'm saying, okay, you're suing me in Durban, but you did not serve me after the 10 days or whatever, that's an interlocutory application. So in the context of proceedings such as these, to say that proceedings which basically abolish the entire body are interlocutory to that very body is with the greatest respect.
Can an interlocutory application have a substantive outcome?
Of course, it can, but it doesn't mean
Isn't that what would happen here?
Justice Theron, the fact that an interlocutory application can have logic doesn't work like that. The fact that an interlocutory application can have a substantive application doesn't mean every application that has a substantive application is therefore an interlocutory application. It can be.
I'm asking you to break it down for me, Mr.
Yes,
Mpofu.
okay, let me break it down. If A is equal to B, in other words, it's possible, as we say, can, that means possible. Is it possible for an interlocutory application to serve substantive outcomes? Yes. But does that mean every time there's something that has a substantive outcome, it therefore is an interlocutory application? No. So that's in logic, it's a syllogism. So the one thing doesn't apply both ways. So if I say a car is a vehicle, it doesn't mean every vehicle is a car.
I'd be putting it mildly if I didn't say I was confused. My last question. Why should this court be a court of first and last instance on the merits of the recusal application? This court is very, very reluctant to do so. We do so in rare and exceptional circumstances.
Yes, thank you, Justice. Yes, that's the question I think Justice Machit had posed. Well, the shorthand is really what I presented in which is that this case is, for the reasons I articulated already, a much better case than the Ramakatsa case, which was heard by this court as a court of first instance. And the reason is that case was heard is what is articulated, I think, in paragraph 16 of that case, which was that to do otherwise would have been to allow a devastating illegality to visit South Africa. So here, ironically, the respondents themselves make our case. What do they say? Court, this matter involves the most egregious matter of the non-prosecution of apartheid atrocities of people who committed heinous crime. It involves victims, sorely so, who have waited for decades for justice. And it is not in the interest of justice to make them to wait any longer. And we say we agree because to prolong the pain of the victims, let alone the potential implicated persons who might face all these other calamities, like going to jail, as we know, if they don't honor the subpoenas. In the case of Mr. Mainecha, he will tell you the risk, what we have posed as a risk, has actually materialized in their case, because they've now been served with a subpoena for President Mbeki to appear, and they had to go to Asian court and all that. We have not, but that's proof of the enormity of this matter. So, in which world would a court allow down the road a patent illegality of a commission, so-called, that is going to investigate to nowhere, which is plainly illegal, chaired by a person that we should not be chairing it, millions of rands later, after we've traveled all these roads, back to the High Court of SCA and so on, while the millions are rolling, and then one day, in 2 years' time, it's found that, no, that was a nullity. So that's even worse, as we say, than the possible calamity which would have befallen the citizenry in Ramakatsa. Because the Truth and Reconciliation Commission cases is something that affects this. It's the foundation, as they say themselves, the foundation of this very democracy was based on this granting of amnesty or the refusal thereof. So this is the case that it would be a travesty, with the greatest respect, or let me put it positively, it is in the interest of justice, blatantly, that the merits should be dealt with. Secondly, as I've said, there's already the wisdom of so many other courts, and the merits have been dealt with by the minority judgment, unlike...
Thank you, Mr. Thank you, Justice.
Advocate Mpofu, we've long gone past our break time, but we insist on taking it now. The court is going to adjourn for 20 minutes.
Thank you.
So let me assist you. Give me the rules, let me assist you. So if we go here, it says, right, and then 3.3.7, it says...
Makatsa court. So which political right you are under really doesn't. The issue is that, as you correctly, there must be that political right, or I'm sorry, that fundamental right, and more. And now, so to answer your question, the more is not whether is this right, or the more is what was articulated by. When we come to the merits, the court might differ with. So that's why the court said, if what you are saying is true, if indeed there are these misconducts, if there is this egregious breach of the rule against bias, if there's all the breaches of Section 34 and NEMO UDEX and all that, if all that is true, what...
If I were to ask, the other two members of the, did they contribute anything or nothing at all, or they were just sitting there hearing the recusal application?
No, they contributed a lot, especially...
What exactly happened? They asked questions?
Yes. Oh, very much, especially Justice Homo. I remember there was...
So they brought themselves into the line of SARF?
Absolutely.
Of SARF?
Yes, they did. And on the basis, yes, the answer is yes. They participated fully, and as with any panel, as like this panel, and they were not just sitting there as passengers.
So now why do you say it's a judgment of one person, not a collective?
Because it says so. It's common cause, as Justice Ferron said. It's common cause, fortunately. If there was a debate about it, it would be. This, fortunately, is common cause. And the reason it's common cause is because they are constrained to agree. It says, in so many words, you'll see the word I appears about 6 times in that ruling. I think this, I think that, I. And then at the end, it's then signed by one person. But as I say, mercifully, when we raised that point, the other side agreed that it was done by one person. They then tried the gymnastics of saying she was entitled to, in other words, it was a confession and avoidance. They said, yes, she only took it herself, but she was entitled to because of, which is wrong, because that cannot be the case. Rule 3 specifies this.
But couldn't it be interpreted or understood that she addressed it, obviously with the concurrence of the two other members, by using singularly, because the allegations were leveled against her only?
No, Justice Matopo, with the greatest...
Is it a bridge too far?
That's a bridge, it doesn't even exist. The point is that she would have then said, as all judges do, I'm now talking for the court, let's say, for example, and this is our finding, and the others would have signed, the others would have associated themselves. As I say, Justice Matopo, and this is a serious matter.
And they did not concur?
No, they didn't concur or dissent. That's why I'm saying, in all seriousness, as we're sitting here, neither yourselves, with respect, nor me, or all of us sitting here, know whether they agreed or disagreed. It may well be, for example, why we've asked this question and nobody has ever answered it. Why is this section 47 point only raised in relation to the chairperson? Why is it not raised in relation to Justice Homo? Why? Because he's a judge. He's a retired judge. Why?
Sorry. Just come again.
Yes. Yeah. Let me say this.
Yeah, no. I heard you.
Yes. I understand. I'm saying Justice Matopo, and say this.
So the 47.1 point was only raised against the chairperson?
One person, yes. And we've raised this enough.
But wasn't it raised against the chairperson because she is the one who was asked to recuse herself? That's
not it. It's raised against the chairperson because we cited her as the first respondent. But we also cited Justice Homo as the fourth. So that's why it was raised. So why? And I'm venturing to say, and we raised this question under oath. Nobody has ever answered it. That's been dodged. And we venture to say it might well be that Justice Homo wanted nothing to do with this award or ruling. And he could have equally agreed or concurred. The issue, as I say, we don't know. Neither do you, nor us. But that question lingers as to why nobody is saying you should have asked the Judge President of the Northern Cape for consent with Judge Homo. He's left alone, and that's because this is a one-person show, which it shouldn't be, because the entire panel, as you correctly pointed out, Justice, heard the matter, participated in the matter, as it did in the other recusal application of Advocate Semenya SC. And the panel, in that case, issued the ruling. Out of the blue, this one is different. It's a one-person show. That, as Justice Modiba says, alone shows you the egregious nature and the unsustainability of allowing this to continue, which goes back to your earlier question about direct action. Why would you allow something that is so patently illegal on any interpretation to continue simply because you must go to the High Court? When it's clear in front of all of us that this is an illegality, on that basis, on the basis of the reasonable apprehension of harm, which Mr. Manager is going to talk about, or at the very least on the basis of the actual bias that we plead, and also say in the alternative. So if it's true that she advised Advocate Semenya to say, you must argue this, you must argue that, putting it broadly, deliberately. If that is true, assume for a minute that is true, then we all know that we're dealing with the worst form.
No, but whatever allegations you may have asserted against Semenya, let's see, was there any evidence except whistleblower?
No, Justice Matopo.
When I read the record, I did not find any interaction between the chairperson and Advocate Semenya SC.
Well, that's because the lack of candor that goes with...
No, but was it there?
Yes, let me assist you, Justice. That's why we say that not only were there bare denials, which should count for 0, quite frankly, but there was corroboration of our version. We accept, as we must, that we did not bring a confirmatory affidavit of the whistleblower. That would be absurd.
But what must this court do?
Yes,
then?
sorry. Pardon?
What must this court do if you don't have any confirmatory affidavit? It's an allegation that has been made. It's not supported by any confirmatory affidavit.
Okay.
What is the status of that allegation?
Yes. The status is the following. I think the chairperson uses the word smidgen. She says there is not a smidgen. Firstly, that is not true. The allegation is made under oath by a human being. That's evidence. The allegation starts firstly. The reason why people testify in court in in the witness box and swear to God that they're going to say the truth, is so that that statement that they make is evidence. That's number one. Number two, when, as we all know, Plascon, Evans, Whitman, all those cases, when an allegation is then made and it is met with a bare denial or nothing, then the court is entitled to assume that that has been admitted. Thirdly, if there is information which is in the exclusive knowledge of a particular party, that's Rules of Evidence 101, and that party is not forthcoming with that evidence, then the court is entitled to assume that there is a prima facie case of that. You won't quibble with all those three. But here's the fourth one. If you go to 011836, because they want evidence. Here's evidence which they provide themselves. We show them that there's corroboration, or there's non-denial, and all that. We then say, to make matters worse, I'm reading at paragraph 37. In the course of preparing this affidavit, on whatever day, I observed a television interview on Newsroom Channel heard the official spokesperson of the Commission, Mr. Lionel Adendorf, while being questioned by the host, Mr. Kolim Ngambi, on whether the chairperson was perturbed by these allegations. These are the allegations of misconduct. Replying as follows, quote, "She is an amazing person. I spoke to her earlier, and I just want to make reference to where she advised the chief evidence leader on the matter. She does that to me often. She does that in the normal course of our work where we talk regularly about things, and there is nothing wrong with that. She's not concerned at all. She's not concerned. Now, what is he saying? He's saying...
Mr. Mpofu, doesn't it happen in the normal course of events that the chairperson of commission interact with the evidence leader or leaders?
Of course, it does.
It does.
It does, but please, Justice, bear with me here. There is a big difference between the chairperson. I've been in many commissions, and those interactions happen. One of them, evidence management, Badland. The chairperson interacts with the evidence leaders. No problem. Nobody can have a problem. But to want to surreptitiously equate that, as the other side does here, with a situation where there is a recusal application of the evidence leader, let's say in this case it was, which is in itself an adversarial proceeding on its own. That adversarial proceedings, if you work with me, has got the evidence leader who is being accused and the accusers. Now, a person who's trained in law says, with these two adversaries, I'm going to advise only one in the absence of the other. In S versus Roberts, which we cite in our heads, if you bear with me, Justice Matop.
But am I not taking you away from the...
No, this is crucial. Actually, I welcome it, because remember when I was doing my summary, I just brushed through what I call the actual bias allegations. No, you're not taking me away at all. This is actually the heart of the complaint. Remember, I said, to the extent that we have overlapping complaints with Mr. Maneche around NPA and so on, I won't address those. But these which are not overlapping and are unique to President Zuma need to be addressed. Sorry, Justice Matop, if you just allow me one. It's quoted in our heads. I'm so sorry. Page 44, which will be 006.1-44. The SCA said in S versus Roberts. In fact, if you look at paragraph 116, it starts where we started now, Justice Matop. It is common cause that commissioners and evidence leaders communicate frequently. We don't quibble with that. The issue was not about the frequent communication between the chairperson and advocate Siminya SC as the chief evidence leader. The issue was about communication between the chairperson and advocate Siminya as a litigant in his recusal application before the chairperson. The rule against bias prevented the chairperson from communicating with Siminya SC as a litigant in the recusal application without the presence of the Minister of Justice and the National Prosecuting Authority. If I may pause there, that's why the NPA is here today, to say we want the answers, because if this has happened, it has a direct bearing on our application. Then the SCA in S versus Roberts makes it plain that, quote, justice must publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret, that the presiding judicial officer should have no communication whatever with either party except in the presence of the other. That is so fundamentally important that the discussion between the magistrate and the prosecutor in the instant case warranted on its own, without anything more, the setting aside of the sentence. Had such a discussion occurred before conviction in this matter, there can be no question but that the conviction also be fatally irregular. So what the SCA was saying there is that merely, forget about what was discussed on the evidence, whistleblowers and whatever, merely the breach of that rule in an adversarial setting. I don't have to explain that to this court. That's why sometimes, even if we're going to say the most innocuous thing to the judge, we have to bring the opponent to be there in chambers. And the opponent sometimes is just there and grudgingly. But you can't, everyone knows this. That's the biggest breach of the rule.
Thank you.
It's a pleasure.
Mr. Mpofu, I thought one of my colleagues would ask this, but I'm concerned about this pray for period of cost against the chairperson.
Yes.
Are you persisting with it?
Yes, we are.
Now, I find that quite disturbing, and can you please illuminate it? I know you've dealt with it. Why?
Yes. The prayer for personal costs, thank you so much for that, Justice, because, again, it's a matter because of the truncated nature of my initial address. Prayer for personal costs starts as follows. Remember where we come from. By the time we get to that, we would have now accepted that we are dealing with a chairperson of a commission. Could have been judged in any chairperson commission. Now, a chairperson of a commission of inquiry, any commission of inquiry, has got what one would call, Justice Majid, a heightened duty to fairness. Again, if everything God's cost would come at the end. If the alleged misconduct, take this, Justice Majid, if you allow me. One of the reasons on which we rely for the actual misconduct charge is that this chairperson, I mentioned this, went up, and this is now specifically for President Zuma, went and did what we call a media campaign, vilifying President Zuma by name. Now, if that has happened, and there's no, all these things about there's no evidence. Here, there's evidence, hard evidence in front of you, of those interviews having taken place, and mentioning President Zuma by name. And sorry, Justice Majid. If you go to 011 255. I'm getting a letter from Mr. Manager because he likes. It says. No, I was glancing at Mr. Manager because he told me that it's his favorite part of the case. If 011-255, look at that, Justice. The heading, it's a News 24 report by a certain Karen Mon. Says we could not pander to Mr. Zuma. It's not general. We could not pander to Mr. Zuma. Khampepe on why Court had to send him to jail. It says, and then it says, it has now been a year since the Constitutional Court, whatever. And then the next paragraph. Now, in the first part of an exclusive interview, recently retired Justice Sisi Khampepe explains why that judgment, which she wrote, was essential to protecting the rule of law in South Africa, and so on. And then she goes on to say, Mr. Zuma believed he could test the limits of the judiciary, and I believe the judiciary demonstrated that nobody is above the law. We're all equal before it. Now, this person knows that the judicial code of conduct of this country says that a judge may not do an interview about a case where they said that's it's not even debatable. Sorry, Justice Majid, if you allow. I'm sorry. You'll find that at 011-4 to 45. The Judicial Code provides that a judge must, quote, save in the discharge of judicial office, not comment publicly on the merits of any case pending before or determined by that judge or any other court. Rule 13.
Sorry, has a complaint been laid to the JSCC against this?
I'm coming to that. Rule 13 says, which provides further that a judge must not enter into a public debate about a case, irrespective of criticism, because that's what she seemed to have been responding. Irrespective of criticism leveled against that judge, the judgment, or any other aspect of the case. So it's clear nobody in this country would say this rule has not been breached. Now, in the face of that clear breach concerning President Zuma, I ask this rhetorical question of any one of us. Would a reasonable person in the shoes of Mr. Zuma, which is what you judges are expected to do, put yourself empathetically into the shoes of, would you, in spite of these breaches, still think you're going to get fairness in front of this person? To come to your question about the Judicial Service Commission, we say in these papers, in no uncertain terms, and fortunately my learned friends seem to have understood this, because we know we're not asking this court to now be some pseudo JSC. All we're saying is that President Zuma has said he is going, as soon as these proceedings are finalized, because there's no time left, he's going to present to the JSC these two complaints, the one about the collusion and the coaching, and this one. And he says, I'm merely presenting it to this court, not for the purposes of this court finding misconduct, but for this court to answer the question that I just posed, whether a reasonable person in that position, whether there isn't the clearest case under the sun of a reasonable apprehension of bias.
Can you ask your juniors to direct us on the case lines?
Where that portion
but in the
is,
meantime, you can carry on just to save time.
It can be far from here, from what I've just read. Please.
Probably towards the end of the affidavit, right?
Yes, it might be, yes, because you're right, Justice. It is probably, that's where it does the disclaimer, yes.
Let them end their fees, Mr. Mpofu. Let them look
well, it's about time that they end their fees, yeah.
Get on in the meantime.
I'll give them a clue. It's in the funding affidavit.
They will direct us on this.
Yes, they'll direct. But to paraphrase it, Justice Majid, we say this twice. We say the JSC issue will be raised with the JSC, as it should, but here we want this court to look at it only on the basis. And that is why, if you remember, in our supplemental affidavit in the review, after the recorded, we said we abandon the complaints to do with the finding of the Constitutional Court in the Zuma matter. But we said what we specifically do not abandon is this complaint about the media campaign. Which
can I just say that, and I'd like us to move on. I'm very pleased that you've abandoned those
yes, so am I, if I may say so myself.
That was very troublesome. But can we move on? Are there other grounds apart from the media interviews? I mean, I saw at paragraphs 131 onwards in your written submission that why you say there's a personal cause for this justice.
Oh, yes.
Yeah.
Sorry, I forgot actually. The reason why I'm saying, again, I'm saying assume all this is true. So I'll put that aside. Now, that being the case, in the case of the public protector versus South African Reserve Bank, which we quote, which we rely on in our heads. Sorry, just.
I've got it, it's paragraph 129, but while you're there, can I ask you, we all know that case.
Yeah.
In that case, the public protector was found by this court to have misled the court on a pertinent issue. So how is that case comparable to this one?
Okay, that case, which was given by none other than the judgment by Khampepe J, said the following. One, when there is an allegation made against you and you become cagey, as we say here, about Rule 53, and you don't disclose a Rule 53 material, number one, that is a reason for you to be mulcted with punitive and personal costs. B, Khampepe J said, if there is a higher threshold, I'm paraphrasing again, I think it was paragraph 153, there is a higher threshold for people who hold public office, and we say that applies equally to a public protector and the chairperson of a commission of inquiry. What's sauce for the goose is sauce for the gander. And if she, Justice Khampepe, was prepared to lay down a rule that says, if you hold that important office, well, okay, they're still not ending their keep because it is 153, so I was right. But paragraph 153 says the public protector falls into that category of public litigant. Sorry, it's that.
Mr. Mpofu, paragraph 153 talk about when they're public officials.
Yes,
when
sir.
their defiance of their constitutional obligations is egregious, it is they who should pay the cost of the litigation brought against them and not the tax. What constitutional obligations were egregiously breached here?
Okay, if I may just start to say that a higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. The need to hold government to the pain and duty of proper courts process is sourced in the Constitution itself. This is because the Constitution regulates all powers, said Justice Khampepe. And the same considerations of a public litigant who, for lack of a better word, for being general, whose conduct really amounts to the wastage of the taxpayers' money, whether that is because of an investigation that is ill-founded by a public protector or a so-called commission of inquiry that is doomed to nothingness, such as this one, where the actual person appointed, I don't want to. So a public litigant who digs her heels with the greatest respect against this flurry of evidence. I've already said the thing about the NPA. I won't repeat. I've said the things about the HRIU. I've said the things about the Amnesty Commission. I've said the connection with the subject matter and the competent witness of Justice Saldana and Mr. Nuka. I've said all of those things. Faced with this overwhelming evidence, forget about actual bias for now. Just say, faced with this at the level of the perception of bias. And the person says, no, I'm stubbornly going to stay here, whether the president likes it or not, whether these litigants I've given interviews all over the show about them, whether I'm alleged to have given advice to Mr. Smenya, and the spokesperson has confirmed that advice was given. All of that. In which world can such a person be entitled to get all of us sitting here, waste the time of this court as I say, pursuing commission that is 1,000% to not to produce any outcome for the victims or for the alleged catered. This commission will never, I can say that, put my head on the block. Its outcome is going to go to the dustbin of history because of these very egregious...
and let's just tone down the language a bit, Mr. Please. Well, let me end there because I think the language is now increasing in tone. So I want to ask, you've answered the question.
Well, okay, well, if I may then on that, because I don't... this is an expression that is used all the time as to when something is just to fail. Maybe that's what I should understand why that... if that kind of language, which is used in the SARB case against the public protector who was allegedly wasting taxpayers' money, was good enough for that public protector. It's good enough for any public official. Doesn't matter who he or she.
Talking about this expression of it to be confined to the dustbin.
Yes, that's the expression which I'm saying is an English expression which simply means that something is doomed. It will never see the light of day. Maybe I put it like it will come to naught, zero.
Thank you, Advocate.
I'm indebted to the court. Thank you very much. If the court can just bear with us while we do musical chairs.
Yes.
Just a minute.
Are you ready, Advocate Manager?
Yes, DCJ, I would say tomorrow, but it is today that I must be ready to address the court. Yes, I'm ready, ma'am.
Thank you. Please go ahead.
Thank you, DCJ and Justices of the Court. I will address 3 topics and then conclude. First is to deal with the Section 47 and why we say direct appeal should succeed. And 2, I'll deal with the review of the ruling and direct access. Sorry, the first part was direct appeal. The second one is review of the ruling and direct access. And I will focus on the review ground relating prior institutional roles or activities of Justice Khampepe. Then 1.3, I'll deal with substitution in the event that the court were to accept our submission that direct access should be granted and the court enters the merits of it, and then I'll remedy. You will have seen that there are certain aspects between the case for President Zuma and our client which overlap, but there are very specific, distinct aspects which differ. One of them is what my learned friend said was my favorite part of the case. I have no favorite part of the case. I'm simply presenting the case for my client, Mr. Mbeki. Can I foreground the submission we're about to make with President Mbeki is not avoiding, like all citizens in this country. What President Mbeki is asking for is simply to assert his right, constitutional right, and the rule of law. And that is the context in which he raises the recusal issue. If this court were to enter the merits and decide that there is no unlawfulness, and the commission is properly constituted, my client stands ready to account before that commission. But he will do so subject to this court determining whether his complaints are valid in terms of the Constitution. And I turn to Section 47. The proper interpretation of Section 47 implicates the right of access to court in Section 34, especially in this case which concerns recusal, because Section 34 is front and center with the questions of impartiality before any proceeding, whether that proceeding is investigative or adjudicative. And this engages the obligation on courts to adopt an interpretation under Section 39(2) of the Constitution, which promotes the spirit, purport, and objects of the Bill of Rights, even where the issue is not raised by litigants. And this court has repeated that obligation on numerous occasions in its judgments. I don't need to cite authority. So point here is that there is a constitutional point directly raised because the majority did not even refer to Section 39(2) of the Constitution in interpreting Section 47, even though it was made, the submissions were clear that there is an implication on the right of access to court. The matter also raises an arguable point of law of general public importance to be considered by this court within the meaning of Section 167(2). And the point of law has prospects of success, which is evident from the dissenting judgment, and that this court too has emphasized in de Klerk, one of the cases, that where there are dissenting judgment, that's evidence of prospect of success. The second point, which is observed by Mudibache in her dissenting judgment at paragraph 30, is that indeed this case raises a novel point not previously determined by this court in relation to Section 47 of the Superior Courts Act. First, you're dealing with a retired judge sitting as the chairperson of a commission of inquiry, where the proceedings that is said to require Section 47 arise in the context of a recusal application. So that is not an issue that has faced this court before. We submit that the majority's approach in interpreting and applying Section 47 was wrong, and in our analysis of that judgment, it rests on three core but wrong propositions. The first is that it borrowed from the definition of service in the Judges Remuneration Act, and it did so in upholding the reasoning in Mantashe at paragraphs 34 to 46 of the majority judgment, and that is the reason at paragraph 45 of that judgment, it says a retired judge performing a public service is covered. And the second is that the judgment seems to suggest that the second basis, that the application targets Justice Khampepe in her person because the relief sought includes that her conduct must be declared unconstitutional, and you'll find that at paragraph 39 of the majority judgment. The third proposition is, it says, and this we accept is not always clear, it seems to suggest that chairing commissions of inquiry involves the performance of judicial functions, or that the judge does so in the capacity of a judge, and you'll find that at paragraph 54 of the majority judgment. We say both three propositions are wrong for the following reasons. First, it is not permissible to borrow from the definition of service in the Remuneration of Judges Act to interpret the breadth of Section 47(1) of the Constitution. This court has emphasized in Independent Institute of Education, PTY Limited, at paragraphs 18 and following, 6 core principles, or perhaps there are 6, which guide when you can borrow or why you shouldn't borrow from a different statute. The first, and I'm just going to highlight 2 of them, and the court is well aware of them. The first is that, first, a special meaning ascribed to a word or phrase in a statute ordinarily applies to that statute, and the last one that I highlight is identified as the fourth, is that a definition of a word in one statute does not automatically or compulsorily apply to the same word in another statute. You interpret the statute in its context, having regard to its purpose and the language used. You will see that the Superior Courts Act does not even contain the definition of the word service to justify borrowing from another statute to give it meaning. And the 2 statutes are not in parimateria, because the Superior Courts Act deals more with the administration and functioning of courts, whereas the Judges Remuneration Act provides for the remuneration and conditions of employment of judges. So there is no principled reason why one borrows from the one definition to interpret provision in the Superior Court. The second proposition, that President Mbeki seeks relief against Justice Khampepe in her person, is wrong, because he seeks no relief against Justice Khampepe in her personal capacity. She's only cited in her official capacity as chair of the Commission of Inquiry. To the extent that any liability is established, that is attaches to the office that she occupies and not her person. The third is that chairing a Commission of Inquiry does not at all involve the performance of judicial functions. My learned friend Mr. Mpofu referred to the ruling by Justice Khampepe at paragraphs 39 to 40, which makes that very point. And Justice Majid correctly pointed out that that's the opinion of Justice Khampepe, but it happens to be consistent with principle established by this court, because in President of the Republic of South Africa, Sarfu, at paragraph 147, this court says that a commission of inquiry is an adjunct to the policy formulation responsibility of the president. It is a mechanism whereby he or she can obtain information and advice. It doesn't determine rights and wrongs, doesn't issue binding decisions or orders as courts do under 165(5) of the Constitution. So we criticize the judgment of the majority, but then what do we offer as the proper interpretation of the section? We say as the start, one must read section 47(1) in the context of the entire provision, including section 47(2) and the Act as a whole, with proper regard to its language and purpose, as well as the obligation in section 39(2) of the Constitution. And you will see the dissenting judgment does pay regard to broader purpose and the context in interpreting the provision, which the majority fails to do. Why do we highlight 39(2)? We say it implicates access to court because if we are required in challenging the lawfulness of the recusal rule to get consent from the Chief Justice in this case, when the Chief Justice says no, consent is given, then my client must submit themselves to a process where they have, in their view, rightly raised an issue about impartiality without having that issue properly determined by a court. And it is not readily apparent from section 47(1) and the entirety of the Superior Courts Act what remedy my client would have in the event that the Chief Justice says no. Do you appeal? Where do you appeal to? Do you review the Chief Justice's decision? If you review or appeal, do you cite the Chief Justice? If you want to cite the Chief Justice, you need consent. Is it not a vicious cycle in which rights are undermined? So when you interpret the breadth of that section, one has to bear those into account, that you want to adopt an interpretation which promotes the rights of access to court, not simply limits them as less as possible, but promotes them, because that's what the law says. Now, let's look at purpose. The minority judgment with which we agree identifies two purposes, and you will see that in paragraph 33 of that judgment. The first, it says, is to protect judges against frivolous and vexatious litigation in which they are targeted due to their work on the bench. And the second is to ensure that appearance by a judge in court does not disrupt court proceedings. Those are purposes which have been identified in the many judgments which the High Courts have given, and most of those judgments were by judge presidents of those divisions, so they carry some weight, we would submit, because those are people charged with the responsibility of properly administering courts under the Superior Court. We say that this identification of the purposes of the Act is supported by the long title. You'll see the long title refers to the proper the provision for the administration of the judicial functions of all courts, including governance issues over which the Chief Justice exercises responsibility. And then section 94C, which we emphasize, access to courts, recess periods and attendance at courts. It says in subsection 4, subject to subsection 1 and 2, the head of each superior court is responsible to ensure that sufficient judges of that court are available to conduct the business of the court at all times that the court is open for business, issue directions to the judges of that court with respect to their attendance at the court and absence from the court during recess periods, approve extraordinary absence of judges and keep registers, etc. So that's about ensuring that the court can function. And that's reinforced by section 47(2). And to Justice Colopin's question about the relationship between 47(1) and 47(2), we accept that 47(1) governs the consent requirement, but 47(2) operationalizes. Once that consent is given, you'll see there's consent to issuing notices of motion and consent to subpoenas and summonses. And then 47(2) speaks specifically to the summonses and subpoenas that the attendance must be arranged with the head of court to avoid disruption to functioning. That, we submit, emphasizes the purpose of the provision read in the statute as a whole to ensure the proper functioning of courts and to protect courts judges against vexatious litigation arising from their judicial functions, because their judicial functions, where wrong or right, must be appealed if you are aggrieved, not you must sue them. So that's the immunity. And we accept also that those two together, the purposes, help achieve and protect judicial independence. So they are linked to judicial independence. Our first submission is that these purposes, properly construed, are applicable to active judges and retired judges called upon to judicial functions. And so in that regard, we would submit that Justice Benenge, JP, was correct, and as he then was, Justice Mlambo was correct. We differ only with Justice Mlambo with the reference to service, which is borrowed from the Judges' Remuneration Act. We agree with both to that extent. And we submit that there is no contextual, purposive, or textual support to extending the provisions to retired judges serving as commissioners in commissions of inquiry and cited in those capacities nominally other than by borrowing from the definition of service in the Judges' Remuneration Act. Because judicial commissions of inquiry do not judicial function. And suing a judge in that context does not relate to suing them in respect of matters arising from their performance of the judicial function. So that's our principal submission, is that it doesn't extend to the nominee officer position where you're performing other than a judicial. Even if you are there chosen because you're a judge, an accountant could have been chosen. The second, and that's the alternative to the first, we submit that even if we're wrong with this first submission, the provision ought not to apply to review proceedings against a refusal to recuse. And we say this because recusal applications are internal to the proceedings in which they are brought and are determined by the presiding judge or officer or commissioner. And where you have recusal proceedings brought in court proceedings before a judge, there is no debate that Section 47 is not triggered. Even the appeal against a refusal is not triggered. We don't see any, I hesitate to use doctrinal because I'm not sure I quite understand what it means, but there's no principal basis on which one can distinguish between a challenge to a refusal to recuse by way of appeal and a challenge to a refusal to recuse by way of. The only difference is the threshold for getting the relief. In that, in appeal is correctness, in reviews you're looking at lawfulness. But the end result is to secure a recusal. And that purpose never changes because you started off with a recusal application but ended up with an appeal or a review. And we submit that the essence of the proceedings remain the same, whether you're challenging a refusal to recuse by way of appeal or you're challenging a refusal to recuse by way of. And it's very important in the context of recusal because recusals, as we understand them, are sui generis. I think it's State versus +1. They're sui generis. As Safu says, in the first instance, a recusal application calls upon the judge to make a decision based on their personal conscience. It's very difficult for a head of court to second guess whether the refusal was lawful or not. Often when you don't know the full facts on which the recusal was brought, which the judge or the commissioner knows, but may not have been placed on paper. For example, in this case, where there isn't really a full disclosure. So what we agree with the minority, that recusal proceedings are defensive in character. You are forced to appear before a panel, and in asserting your rights to say, but this panel is not properly constituted because I apprehend a bias on part of a panel member or the whole panel. They cannot classically be construed as being proceedings against a judge. You don't obtain relief against the judge against whom a recusal is sought. All you're asking, you don't ask that liability be attached to the judge. All you're asking is for the judge to step aside in order for the proceedings to run without the attendant apprehension of bias. So our submission tracks what our learned friend Mr. Mpofu says, that we accept, Justice Teron, that it's looking at the provision, it's difficult to submit to the court that review proceedings in the High Court against a refusal to recuse are not civil proceedings. They are classically civil proceedings, and I haven't looked at whether sui generis means they are neither, but it might be that they are of a different form, but for present purposes, I'm not pressing that point. I'm pressing the point that the provision requires that civil proceedings be against a judge. And often in that case, the judge will be a party and another judge will determine right or wrong. Whereas in a recusal proceedings, the very judge who's asked to recuse themselves is in the first instance by law required to be the determiner of the application. And the challenge to that determination, where it's a refusal, is simply to say it wasn't lawful. It is not, it doesn't change into a kind of an application to fix liability on a judge, against a judge. And so we submit that when that recusal succeeds, the obligation then rests on the appointing authority to replace if there is a vacancy that must be. It is that appointing authority which bears the consequences of the recusal being approved. In the case of a court, the head of court will appoint a new judge. In the case of the commission, the president might appoint a new judge or a commissioner, or might say the current commission continues as constituted. And a prayer for cost doesn't change that, because except for the arguments the court had with my learned friend about personal costs and liability for personal costs, ordinarily costs where you're acting in an official capacity, the liability to pay those costs will be on the public body that appointed you. It wouldn't be on the commissioner or the judge in this case. And the question, of course, is entirely within the discretion of the court. So to protect the presiding commissioner, to avoid attacks, you could refuse personal costs. So it doesn't change the nature, we submit, but of the proceeding. And that's the basis, the two bases on which we say the majority was wrong and we say the minority was correct. Now, we ask for direct access if the court is with us, that we are right on the Section 47. And we must satisfy the court first that there is a case for direct access. We say there is. Firstly, this case was brought on an urgent basis in the High Court. There was no dispute in the High Court the matter was, because the constitutional validity of the composition of the commission is a matter of huge public importance, given the task it's required to perform. And so the matter proceeded on an urgent basis. Nothing has changed, other than that the lifespan of the commission has changed, been increased to December. But in the meantime, my client has been issued with a subpoena, was meant to have appeared before the commission in May, but having approached the High Court on an urgent basis to await the outcome of this court, that subpoena was suspended by court order to the 1st of September. So come the 1st of September, and this court has not dealt with the merits of the review, my client is compelled by that subpoena to either appear or to go again to court, to ask that awaits the decision of this court. There is no time to obtain a final decision from the SCA on both the Section 47 point and the merits. To correct that point, we have not yet been given leave to approach the SCA. We only have a conditional application in the High Court for leave to appeal. The majority in the High Court may still refuse leave, in which case we'll have to petition the SCA. The petition may or may not succeed, and then we may or may not be heard by the SCA. The outcome of the SCA may be subject to an appeal to this court. By that time, either my client would have been forced to appear before that commission, despite the rights that he is asserting, or that commission would have ended without my client's contribution being heard by a properly constituted commission. And we submit, and we have all the faith in the courts. We have great respect in the judiciary and the huge function that the judiciary carries in our constitutional democracy. We have no doubt about it. But it's simply humanly unlikely that we would have a final judgment by the SCA on the 1st of September for purposes of and the superiorities away. Finality in respect of recusal disputes is required and certainty is required. This court emphasized this point in Bennett. I accept that Bennett dealt with the recusal of the SCA judges, and this court said it is the only court that can make the determination, and it must make that determination. But it says, very, very important point about recusal, paragraph 22 of Bennett. These are important. First, at 18 it says, the question whether a judicial officer should recuse himself or herself is a constitutional matter. So too is the issue whether there was actual or a reasonable apprehension of bias, and legal and factual issues that need to be decided in order to determine the question of recusal or bias are themselves issues connected with the decision on a constitutional matter. The question whether the two judges of the Supreme Court of Appeal should have recused themselves, as well as whether the applicant has a reasonable apprehension of bias, therefore, unquestionably raised a constitutional matter. And then it says, but what about the interest of justice? At paragraph 22, the court says this: these are important constitutional issues that go beyond the interests of the parties to the dispute. For an independent and impartial judiciary is crucial to our constitutional democracy. It is therefore in the public interest that these issues be resolved. As these allegations are made against the Supreme Court of Appeal, there is no court that can investigate these issues other than this court. This court, as the ultimate guardian of the Constitution, has the duty to express the applicable law in order to enhance dignity among judicial officers, litigants, and legal representatives, and thereby to contribute to public confidence in the administration of justice. You will have seen that post-Safu and Bennett, there is a debate between us and the Kalata group about whether the standard on previous associations is applicable, and this court must say whether it does or doesn't. This is not about justices of the Supreme Court of Appeal, but it is about a very senior judge, former judge of this court. And it concerns a commission of inquiry at the heart of our democracy, because it is how we manage to heal the wounds attempted to heal the wounds of the past so we can proceed. And one needs that commission to continue all the public confidence that there is. And this court's pronouncement on whether there is or there isn't a case for recusal will enforce that confidence and not undermine it. There is minimal necessity for this court to benefit from judgments of the lower courts. Why do I say this? You have the benefit of the three-bench court, where the minority has expressed itself on the prospects, and we submit that their prospects of success raise the constitutional matter, and the legal standard to apply on recusal applications is well established. And so the court doesn't need to hear what the SCA has to say about those. So we submit that it is an exceptional case to warrant this court's granting direct access. Now we must demonstrate a review ground, even if you agree with us. The first ground of review is the one Malene Trent dealt with, which is the composition of the decision maker. And the proposition of law we make, and Justice Teron asked of us to say this, the proposition of law is a simple one, is that the Commission and the Chairperson are all creatures of statute. They only have the powers conferred upon them by law. They don't have power because the law doesn't say they don't have it. They have the power when the law says they have those powers. And the court will look at Rule 3 at page 011-662. I hope I gave the right citation, otherwise I'll be correct. Maybe 001. It's 001, not 011. 001-662. That rule gives the Chairperson to issue directives and make decisions on specific matters, for instance, about cross-examination of witnesses, the leading of witnesses. Those are powers specifically given to the Chairperson. But substantive applications such as recusal are governed by Rule 11. That rule is very clear, that you bring the application on notice of motion, supported by affidavit. The Chairperson can issue directives on the conduct application. The decision on the application is of the Commission. And so the ultra-virus point we submit is made. Then the second ground of appeal relates to the recusal point. And here the ground of appeal or review that we've raised is that the Chairperson failed to apply the correct legal standard for a reasonable apprehension of bias on the Chairperson's prior institutional roles and activities, or misapplied that test, resulting in irrational. Now, it's important I make this point. So the standard for recusal is a double standard, double reason. But the court has recognized that there are circumstances in which, depending on where allegations of apprehension are based on the judge's prior activities before they are appointed to the bench, that in those particular circumstances, an apprehension of bias may exist if it meets a certain standard. And that standard is set out in Safu and was confirmed in Bennett. And it is that standard we submit that the Chairperson failed to apply, and in consequence committed a material error of law, or in effect failed to determine the matter, and that is a classic review ground, and it would very much equate to what this court said in the Louis Dawes case at paragraphs 26 to 27 of that judgment regarding the failure to apply a correct test or to apply it correctly. Here we say failure to apply the correct test and both to apply it implicate grounds a review basis. And I'm running out of time to deal with why we say so here. But I can say it is very clear, perhaps I can just round up that point. It's very clear in the founding affidavit recusal application in volume 22 at pages 011 to 891 and 011 to 896, paragraph 16 to 34, that the President Mbeki relied specifically on the Chairperson's prior institutional roles as a basis to ground apprehension of bias, and his roles he performed prior to being appointed Chairperson of Commission. I shall stop here in line with the...
Thank you, Advocate Manager.
Sorry, Mr. Manager, just one question from my side. You raised the question as to why your client should have to get consent from the head of court to proceed with litigation, and arising from that, what would the consequence be when consent was refused, given that on the face of it there may not be a remedy and the refusal might be final? Whether one could take that decision on review, I suppose, is an open question. You urge for a more restricted interpretation, if I could put it that way, in relation to 47. That concern that you raise would apply to any potential litigant vis-à-vis any judge, whether sitting or retired, not so. The procedural hurdle of obtaining consent. And if we should take what you say on board, then there's no way we cannot accept it in its fullness and say, well, this should apply in respect of retired judges who are not called into active services, but it should not apply in respect of other judges, because what we're called upon is to give an interpretation to the section. It's not an interpretation that from case to case. So it may seem that the argument you make is an attractive one, but its attraction might be closer or closely aligned to a challenge to Section 47 rather than an interpretation of Section 47. My concern is that we may get to where you want us to get by avoiding the challenge to 47, and I'm not sure if it's permissible to achieve an outcome that may be properly achieved, a challenge, but do it through interpretation. The court could then be accused of simply going too far, the interpretive exercise, when essentially the heart of the complaint is that this provision is oppressive. It's oppressive because it places an unjustifiable procedural hurdle to any litigant, irrespective of the status of the judge, in order to advance a case that Section 4 guarantees. What would you say to that?
So our submission is that one can achieve the outcome we submit by way of an interpretation that is faithful to the apparent purposes of the N39 institution. And this is to say, where you have an active judge, I'll deal with a judge in service. The two purposes we identify are directly, firstly, that when they are sued and have to appear in court, there may be an adverse impact on the proper administration of the court function. So that purpose is served in the case of it. The second also is when they are now sued in respect of where they have faced frivolous suits arising from their judicial functions, when is an active judge, that will readily be met. So it's in line with the immunity which judges must enjoy in order to secure judicial independence. It makes perfect sense that purposively the head of court would scrutinize whether the suit should persist. And that concern would equally apply to a retired judge called back into service, because it implicates the same. But where you have a retired judge who is not in active service at all and is instead appointed by the minister or the president, firstly to chair a commission of inquiry, which is not judicial, and therefore they are being sued, has no implications to the proper functioning of the court, or indeed judicial functions which they perform, then it makes sense to say that the reach of the section doesn't extend to, and you're still faithful to architecture of in the contract act as a whole. So we submit there's a ready distinction to, even before getting to the nature of the proceedings, which was marked on the principal argument, and that's how Judge President Menenge resolved Justice Khampepe. And it's important. There's another error that judgment is unhelpful because intent maintenance and domestic issues are already excluded. That judgment gave rise to that exclusion in Section 47.1. That judgment preceded the exclusion and highlighted the necessity, because even a judge who is accused of domestic violence would need permission if it's a civil proceeding. So we submit that this court has done it many, many times, looking at, Jesus very, very well sets out the very steps for judicial up to section, and preferring a constitutional interpretation. And it's possible within this act. What the majority failed to do was to even engage with this, the consequence of what they say. Because to the extent that they say that it applies to a retired judge sued in their personal capacity, it applies to judges sitting as arbitrators, because those are sued every time when they make rulings that litigants are unhappy. They cite nominal office in their capacity as arbitrators, but that's private, not public. And you would also extend it if you take if you're borrowing it from the Remunerations Act, it's much wider, because even chairpersons of inquiries appointed by minister to be judges would also fall with 47. Sometimes with the court-appointed mediators, these retired judges act as mediators. We have, and facilitators under the Intergovernmental Framework Act. They act as facilitators between disputing organs of state. So the implications of this interpretation to access to court is huge, especially if one concludes that non-compliance or failure to get consent means that the proceedings are a nullity. You can't even condone. And that, we submit, is also another wrong approach by the majority, because if you look at Section 47, it is really regulating the timing for coming to, that you must jump a hurdle before you come. And it regulates access to court. And there are authorities like the Toyota judgment of the SCA that we've cited, which say where a statutory provision regulates access to court, courts have inherent powers to condone non-compliance. So in the case of a provision instituted without obtaining consent, it should be possible for the court to say, we're going to stay the proceedings, go and obtain consent. And it is eminently more reliable for the head of court, given pleaded facts, to decide whether that's a frivolous challenge or not. But where you have a recusal, where you have a consent by letter, no pleadings, so you've only got one version of one part, because the Chief Justice or the head of court is not performing an adjudicative function. Is really expressing what is really a prima facie, that these proceedings are frivolous and consent is refused. But once all the body of evidence is put together and those who must disclose are fully disclosed, the picture might change. The door would be closed. If you say it's a nullity, that's the end of the story. So it does call for a restrictive, constitutionally compliant interpretation, and we submit that there's nothing on the language that is against the submission because the language is very broadly stated. The court can read it down, so to speak. It is not a remedy issue, it is an interpretation issue. When one reads down, it's not reading in. We're not asking for reading in, we're saying read it so that it stays within constitution and does not.
Mr. Meneche, it seems you have two issues of concern with reading it literally, and that would be the width of what would fall under civil proceedings. You argue that recusal are already proceedings within proceedings and they relate to access to, but also to unqualified reference to any judge. So if we are to read it in the way in which you suggest we should, how would you suggest it should read?
Yes.
Without us legislating?
Yes, I do remember once I said to Justice Majid, that's an easy question, but the answer is very difficult. And he said, that's why he's sitting on that side. Today I wish I was sitting there, but...
It's a difficult question, that's why I ask it to an intelligent part of the court.
Justice Khampepe, what's the word? I think I've lost my English. If it was my mother tongue, I would have the right word to express the gratitude. But the point I make is that Justice Menenge, as sitting as a JP, found the reconciliation. And that reconciliation was agreed to by Justice Mlambo, as he then was, save for... And I must say, when Justice Mlambo went further to talk about service, that was orbiter, because in that case, Justice Motata was cited as in his capacity as a judge. So there was no question about Commissioner of Inquiry. So in effect, the ratio of the LP judgment Menenge and by Justice Mlambo is reconcilable 100%. And that is the reading. It is this, that provision applies to active judges in either acting in their capacity as judges or performing open judicial function. I'm careful not to just say capacity because it seems it would implicate both. So it's a capacity of a judge where you can be allocated to perform judicial function, or when you have performed judicial function, or the suit arises from the performance of judicial function. If it's a retired judge, it must be when they are called to judicial function, or a suit arising what they did, not what they were sitting as a commission. And we submit that's yes. And sometimes as lawyers we to get more ambitious about what we ask the court to achieve, but always remembering that we're dealing with the facts of this case. Ultimately, even if you disagree with what we say should be the meaning of the provision, the second alternative point which Justice Khampepe raised about the nature of the proceeding, these proceedings against the judge, may justify a conclusion that even if you disagree on the main interpretation, you agree with us on the application to this. And that's where the fact that similar cases are pending in the SCA may not be a definitive response to our direct appeal, because this case could be decided on a narrow point as the minority and not on the bigger point which those cases spend the SCA to grapple. In other words, it is open to this court to not be definitive on the full interpretation, the primary interpretation we submit, but nevertheless find that this is not, even on the interpretation of that section properly, these are not civil proceedings against a judge. These are sui generis proceedings akin to an appeal proceeding, refusal to, and a constitutional interpretation does not allow. Otherwise, you produce upset results, and our law is clear that where an interpretation, an ordinary interpretation of it may result in upset results, that or interpretation may depart from, and also that they 39. And I must also highlight about Mantashe. The utility of Mantashe must also be factored because that court related to Chief Justice Zondo at a time when he was still the serving Chief Justice. So it is very likely, it's very possible, I don't know the fact, that when the Chief Justice regarded whether permission should, that permission may be required in that case if the suit might have affected the allocation of cases for the Chief Justice in this court, because he was still a serving. So all of these judgments which have been referred to and adopted whole as borders, we're all dealing with peculiar facts which are wholly different from them. And that's why the minority is correct at those paragraphs that I referred to. But this case raises a novel point, which has not been decided by any of the cases that the majority said they were bound to follow, or they thought it was correct.
Good, Mr. Manager. I think, just finally, that what you contend for is an attractive approach, and that's one that may lean strongly towards it being constitutionally compliant. I'm not sure if it simply requires the court to go a bridge too far in terms of what it has consistently said is its role and the line of separation. But I think you've made the argument and it's something we must consider.
Yes, Justice Khampepe, that line about separation is very sharp where you're being asked to read into, because then you're adding to the statute, which is what the legislature should. But here all we're asking is what the court does with it, is properly read it. If the provision is capable of a reading down that retains its constitution, that is the interpretation that this court has to adopt under Section 3 of the Constitution. And the authorities are legion in this court.
Take a short adjournment, not longer than 10 minutes. Just short. To deal with something urgent.
Thank you. The court, please.
Thank you. We may look alert and strong, but we are octogenarians here.
We are also getting there.
Thank you.
Mr. Meneche, just one question. The applicants appear to argue, and the respondents also appear to argue or conceive, that if we approach the merits of the review, we will be exercising direct access. Now, as I understand it, the applicants in this case don't raise any grounds of review that weren't pleaded in the High Court. You treat it, or you call it, direct access because the majority in the High Court didn't reach these questions and decided the case on a preliminary basis. Now, when that happens and a case is brought on appeal, let's assume you get a leave to pursue a direct. It is always open to the court on appeal to say, well, we disagree with Court Arquo's decision on this point, and we must now decide what order that court should have made, and on that basis to consider the issues which the court below left open. The AD and SCA has done it all the time, and they don't have a jurisdiction to entertain direct access. This court did it recently, for example, in APSA versus Commissioner for SARS, not perhaps altogether dissimilar, where the SCA had held against APSA on a point that they couldn't institute proceedings without the prior leave of a court.
Yes.
And this court held they were wrong, the SCA was wrong to have done that, and then we proceeded to determine the merits, and we never conceived of that as direct access. It appears to me that if you get direct leave to appeal and we reach the merits, we will be doing so in the exercise of appellate jurisdiction. As an appellate court, we would have two options. We could say, well, we are going to remit the matter to the court below, or we are going to decide those issues and make the order which the court below should have made. Either of those are ordinary appellate functions. The very fact that we can remit tells us that we're not dealing with direct access because there's already a court where these matters should have been decided. In direct access, if we refuse it, we simply refuse it, and the party must institute proceedings at first instance in another court. I can readily accept that the sorts of circumstances which we take into account in deciding whether to grant direct access might be relevant to decide whether we should admit this case, or with you on Section 47, to attain the points which the majority didn't decide. But unless I'm persuaded to the contrary, that doesn't require direct access.
Yes, Justice Rogers, thank you for that. It just shows which side is the clever side as opposed to Justice Khampepe's earlier suggestion about our standing on this side. Justice Rogers is absolutely correct. I recall that we cited a case in our heads regarding the validity of Commission of Customary Marriages Act, which we cited the SCA judgment, but it came to the CONCO, and the Constitutional Court decided it on an issue which was not decided by the High Court nor by the SCA. And I was on the losing side because we lost on that very point. And this court even called for expert evidence on the existence of a customary rule in order to determine that issue. I just don't remember the case offhand now, but my juniors will ask. That is correct. So out of caution, we asked for direct access, but what we are really trying to persuade them to do is not to remit after engaging the direct appeal. It is to determine the case as a whole. And I do accept that the same considerations for direct access would largely feature in determining whether.
With this distinction, which applicants in your client's position potentially have in their favour, is that they didn't try to bypass court of first instance. They brought their case there, but the majority in that court just didn't address them.
Yes, that is correct. That is correct. So we can ask the court not to remit, and for the same reasons we advance for direct access, ask that should determine the merits. And the merits are in two parts. The first is to exercise the review jurisdiction, whether we are right that ruling must be reviewed and set aside, and then what must happen to that once it's reviewed and set aside. We ask for substitution, which would be a discretionary remedy by this court, to remit the ruling back to the Commission to decide afresh, or whether for the court to say, we've got all the facts before us, we are in as good a position as the Commissioner, and under TRENCON, this is an exceptional case in which we can decide the merits, the merits as in the remedy that must follow the review. And that is the case we ask the court.
I did tell the Deputy Chief Justice I would ask only one question, but perhaps he will allow me to just follow it up on a slightly different but related point. In regard to the contention that a recusal ruling should have been made by all three commissioners, if you overcome Section 47, the court should be with you on that point. What do you say we should do about the other grounds of review? Should we then not decide them, send the recusal ruling back to the Commission for a decision to be made by all three? Because it's an interesting point to run, but unless you are seriously asking that we send back the matter to the Commission to be decided by all three, it's really an academic point. If it's a point you seriously persist with, it appears to me the proper course would then be for us not to consider any of the other recusal grounds or any of the other review grounds, and to just send it back to the Commission to decide as a collective. I must say I'm not particularly attracted by the view that the collective has to make the decision. But it's a point that is raised, and it's maybe not straightforward. So what do you say should happen if the court is with you on that review ground?
So our first submission is, even if the court reaches the conclusion that the full commission should have determined the matter, and that the determination by the chair by herself is ultra vires, it still leaves the scope for the court to substitute along the lines of TRENCON. The considerations that are taken into account there is whether the outcome is a foregone conclusion, in other words, on recusal. And that requires the court engage the other grounds of review and the merits on the recusal. And to do that, is the court in as good a position as the commissioners? Yes, it is. Everything is before the court. The third consideration that's also taken into account is a matter of delay.
If we are in as good a position, but we come to the opposite conclusion to the one you like, and say, well, there were no grounds for recusal on the merits, is there any point in remitting it?
There's no point. I must accept that. Then there's no point, because...
So where does the point go, the ultra vires point? Is it relevant only if we are left undecided as to what the outcome on recusal should be?
It's good if you are decided of the recusal, because then you can substitute, because then it's a foregone conclusion. But if you're unsure, if
If we
not
are
a foregone
sure either
conclusion.
way, then it seems to me remittal's a waste of time.
I beg,
If we are sure either way, if we are
Yes.
sure that there should have been recusal or sure that there shouldn't have been, then there's no point in remittal.
Just Roger is correct. If you're sure that there should have been a recusal, then on our submission, substitution is competent because it's a foregone conclusion and there's a fairness, delay, all of those factors. But if you're sure that there shouldn't have been a recusal, there's no point sending, it's unfair to the Commission, it's unfair to the public interest, even to ask for us to go back and argue something this court has already expressed its view. So it would be the end of that.
Sorry, let me follow up on this debate and just be clear. If you are good on the 7-1, that does not satisfy you. You need to go and consider the recusal.
Yes, you reach the recusal.
In other words, you can't leave this court with, say, success on 47-1 only, and the recusal is pending or nothing is said about the recusal. For you to be successful, both points have to be decided in your favor. Am I correct? I just want that formulation properly.
Yes. So there is a
Because
world.
the High Court said the proceedings absent consent are a nullity. But you would say now, if you're successful to say the High Court was wrong in all its interpretation and construction that this was a nullity. Having said it's not a nullity, you are now in the area of the recusal. And you would say, entertain my application for a recusal. That is premised on the proposition that this would be akin to some direct access because the majority did not deal with it except for the minority. And then you would say, if you are correct on that point, you should be successful. A success on one point would not be good enough. Or am I conflating them?
So I can I can answer to that. Yeah. So we see two options in relation to our application, two main options. So the first option is the court accepts the direct appeal in relation to section 47(1), says leave to appeal is granted and you succeed that the High Court was wrong. If we succeed, this court has two options. It can either send that review back to the High Court for the majority to decide, for the court to decide the review afresh.
But then my point comes in.
Yes.
And if it's remitted back to the majority, if it's remitted to the High Court to decide it, is it the same panel that is going to decide it?
It probably would.
And if it's the same panel that is going to decide it, for which you would have expressed less confidence in that panel, and how can that panel then be in as good a position to decide the review application?
Is that is in part the reason why we say a remittal to the High Court should not be the preferred route for this court, because you're going to send it to the High Court to decide the merits again, where one of the judges has already said that there must be a review.
It falls within the Trencon
Yes.
rationale of a foregone conclusion.
As we submit. So if we are with us on 47, we ask that the court must then do what the majority failed to do. In other words, do what the minority did, which is to decide whether the review must succeed and whether substitution must succeed. And we say that part benefits the public interest, it benefits the Commission, it benefits the families, it benefits us, because this court will either say Section 47 was wrongly decided, review grant is good, but you didn't make out a case for recusal, in which case the Commission carries on with all public confidence. And my clients, having had the final word from this court, will then participate. The second possibility is you will say, as we urge the court to do, is the review succeed, you had a good case on recusal, on substitution, we say there should have been a recusal, in which case the President must act on how that Commission carries on with its work without this complaint hanging on it.
Should it matter to us whether the Commission has gone that far or not, or it's something that should not be of any concern to us?
If the court gets there, the court gets to substitution but believes that there is a concern about what happens to what the Commission has done so far, the court, under Section 172 of the Constitution, would be entitled to call on the parties to say what should happen. In other words, in exercising its just and equitable remedy. The parties will make their respective submissions. The ones might say that everything that was done is a nullity, but the other party might say, well, justice and equity gives you scope to save some of what has been done in one form or the court might say that must be resolved by the reconstituted Commission, and the parties involved, they must decide how those proceedings will continue. But that is on the assumption that the court finds for us on 47, finds a grant of review and upholds the recusal. Then the questions about what happens to the Commission come into the fore. But the question about what happens to the Commission don't feature in deciding whether a recusal case has been, other than in the context of the argument about delay. But it doesn't enter because that's not the test for recusal will be determined to be standard on the facts that have been pleaded regarding recusal. As to what happens to those proceedings, the law has expressed itself in relation to proceedings where a panel member or the whole panel was disqualified. That is a nullity. That's the state of the law. But whether that is automatic in every instance may be something that this court will have to debate if it reaches that.
But it does not seem to me that there is a shortcut to this.
Yes, there isn't a shortcut.
If the tree happens to be poisoned, one can't have a bite.
You can't have a bite. That is what the law says. It's not just us saying so. All of the cases in the SCA say that because recusal goes to the jurisdiction of the panel or the tribunal, once that panel should never have said everything that they've done is a nullity and can't be saved. But we are not engaged in that debate at present. And if this court wanted to have that debate, once it is clear that foresees that it might reach that point, then the court is very free to invite the parties to make submissions on that.
No, but I just want to decline that invitation
Yeah,
about
I understand, Justice.
inviting the parties to file submissions on the just and equitable remedy.
Yes, when the law is clear.
Yeah, but the law says if there is a problem with the constitution of the panel and how it conducted affairs, and how can written submissions ex post facto breathe some new life to use Mr. Mpofu's word, something that is dead in the dustbin. And I understood how it was.
It's Justice Matopa, I'm indebted to clarification. It is consistent with Justice, and that is the law. That is the law. That's the rule of.
But shouldn't we look at it in this way? Put aside everything that has happened and ask ourselves the question. We have a challenge to the challenge is premised on the 47-1. It's not good, right? It meets the order of the High Court majority to set aside. And we look at what brought or what necessitated the challenge. What necessitated the challenge were certain allegations which morphed into some submissions that the chairperson, as a result of her previous institutional role, may have been, and if that argument is good, there's nothing.
Yes, that is correct. That is the law, and that's what the Constitution requires, because Section 1C says the rule of law is a founding value. The Constitution is paramount. If what has been done is inconsistent with the Constitution and the law says invalid, that is what it is.
We haven't tested today, maybe me, I haven't tested with anyone, the role that the chairperson played previously in her previous life, and also the terms of reference. As I recall, the terms of reference starts from the year 2003.
Yes.
Right? Are we able to shut our eyes and say the starting period 2000, and then we are going to consider what started from 2003 going forward? But if what transpired or what could have transpired prior to 2003 had a bearing on 2003, and I was part of, or whoever was part of, or played a role in 2000, how do we separate the role to say 2002, whatever you did, it's not worthy of consideration? We will be looking at 2003, and are there no overlaps?
Yes. So that's a very important question, because it also goes not just to the facts, but to the test that the court will assess. Now, it's not possible to shut your eyes to to what happened before 2003 for two reasons. It is that, as you've seen, the genesis of the commission is the application by the Kalata and the High Court for constitutional damages and for the establishment of a Commission of Inquiry. And the basis of that application was there has been political interference, which starts in 1998 when the ANC leaders engaged in discussions with the apartheid generals to try to find a way to avoid prosecution of TRC cases. That's the first. The second point, it is in 1998 that the Amnesty Committee sends a list of the cases where amnesty was not granted, where prosecutions by the NPA should take place. At that time, the chairperson was both in the Amnesty Committee sending the list to the NPA and in the NPA laying the groundwork for the prosecution of TRC cases. She was second in command. In terms of Section 5 of the NPA Act, she is part of the office of it. So that's what they were doing at that time. Now, the Rule 33 notice that was issued against my client wants him to account from 1998 dealing with those meetings with the apartheid, because they say those meetings happened because the ANC 37 were concerned, or for the ANC were concerned that they didn't get amnesty, they may be open to prosecution, and so they want to do a deal with the apartheid laws, and this informs the genesis. And the notice from the Commission itself calls for the response from President Mbeki and the other Executive Minister Mabanja and President Zuma to account for all of that from that time.
Okay, let's just back it there.
Yes.
If President Mbeki, former Minister Mabandla, or would be summoned to account for the period from 1999, each period would include the terms of reference. And if the chairperson of the commission was present during that period, the period for which President Mbeki is called upon, how does she sit and bring an impartial mind to bear on the proceedings? Can it be reasonably accepted the fact that she says, or the terms of reference talks about 2000, she is insulated from the happenings of the year 1999? One. Secondly, if the former head, Mr. Bulelani, who has already, he probably would have testified about the period before and with the period 2003 to the extent where he was involved. He would have his own cut-off period to say, I was appointed on this day and my term of office ended on this day. I can cover this entire period. If in the process of covering this entire period, the chairperson is there in that period, is it not something discomforting? And put it differently again, assuming Mr. Bulelani Nguga was indisposed and we know that the chairperson was the deputy, could the deputy be lawfully to go and give evidence? And if she could, then what does it make of the process?
She can definitely compel, because both her boss, the NFA, and Advocate Ackerman SC and Judge Saldana, who was in the unit with her, who are all in the NPA with her at the time, are all witnesses who are testifying about that period. And here's the important part about that period, Justice Matopa in the court, is that, so she was in the TRC sending a list to the NPA had to put in place processes to see to it that those that needed to be prosecuted are prosecuted. Now, there has been a failure to prosecute. That's the reason for the commission.
For this commission.
The commission has to basically unearth the reasons for the failure to prosecute. The reasons could either be, as the terms of reference ask, if and whether there was political evidence which accounts for the failure to prosecute. So you could find that the reason for the failure to prosecute to be external interference, or you could find the failure to prosecute internal failures within the NPA. Now, and we've put the witness statements here, as between the NDPP Advocate Nuka at the time and Advocate Ackerman, there's a sharp dispute that Advocate Ackerman says the failure to prosecute was because of external interference. Advocate Nuka says, no, it wasn't. I'm not aware of any external interference. We were doing our work internally. So it is highly possible that after having heard all of this, the Commission may have to make a determination whether the proximate cause, the real reason for the failure to prosecute, was internal or external to the
But there is a problem.
Then she was in that NPA in 1998, 1999, when they were setting up in motion the prosecution. Now, the test which we submit applies where one complains about prior roles or prior activities is set out in Safu at paragraph 76 and was confirmed in Bennett at paragraph 78. And it is this, that prior associations and activities of a judge would give rise to a reasonable apprehension of bias if the subject matter of the litigation, in this case the inquiry, the commission inquiry, arises from your prior roles. So that's what you need to ask. Now, you will read the ruling. Justice Khampepe asked for a logical connection. When she says the logical connection, she looks for an overlap in the issue she must decide now with the issue she decided then, and then she looks for the temporal overlap, which is the 2003 versus 1998. And that is not the test which Bennett and Safu says you. It's a broader test. You're looking at whether this matters now arise from there. Now, they arise from there because it is the failure to prosecute by the NPA which has given rise to this inquiry. This inquiry must determine whether the failure was external interference or internal failures. She must inquire into that. And the families whose family members are the victims are before her in decisions she made to refuse amnesty. She was part of the panel of refusing amnesty, and she was also part of the panel which said, the ANC 37, you don't qualify for amnesty because you haven't confessed to individual crimes. Now, those ANC 37 are the accused, so to speak, in the inquiry because they are the ones that are accused by the Kalata group as having interfered politically with prosecution of TRC cases and must be criminally charged. That's really what this thing is all about. Now, and we're talking about apprehension of bias, not is she going to be actually biased. It's just my client looking on and saying, and the bigger point also is that, unlike in Safu and Bennett, Justice Khampepe has failed wholly to fully disclose what her role was in the NPA regarding TRC cases.
I was just about to get there. Whether do we know prior to 2003 what is it that she did that distanced herself from the recusal? In other words, on the Commission's pleaded case, when it was suggested to allege that your prior institutional role precludes you from proceeding with this matter, is it set out in the answering affidavit to say, yes, I was involved with the NPA during this period, but my period was limited or included only this, and what is the Commission now investigating does not cover period or include that I was with the NPA? No.
What they say is, so firstly, in the recusal application, so the recusal application was a sequel to a letter sent by the Kalata group saying the chairperson and other group played this role in the NPA. If you want to object, you must object. The chairperson acknowledged receipt of that letter, made no disclosures at all. And then there was the recusal application which said you gave advice to the NDP in relation to TRC cases through the HRAU, which was the unit set up to deal with TRC cases. The answering affidavit in the recusal application was filed by our colleague Sumenya SC on behalf of the Commission. He recounted the allegation at paragraph 35 of that affidavit and did not deny it, but argued why that was not a matter of giving rise to recusal on the basis that she wasn't involved in political interference. And this commission is about investigating political interference. So there's no overlap in the issues. Who must get amnesty or mustn't get amnesty is not before this commission. And anyway, the time period starts from 2003. That's the case that is. And we said, but then everything is common cause. What we say is common cause. On the common cause facts, we apprehend bias. In the ruling at paragraph 20, the chairperson says the allegations regarding her prior roles are common cause. The only thing she disputed at paragraph 52 was she has no knowledge of any policy she shaped about TRC cases. She just said, because she says, I have no knowledge, you haven't told me which policy it was. So she never denies that she advised the NDPP on TRC cases. And then,
would you have been satisfied if she had affidavit to say, as the NDPP, as deputy NDPP, all that I did was, say, for example, cash in transit trial in criminal cases. I did not do political cases. That the Commission is...
that would have alleviated...
That would have alleviated any apprehension.
Yes. And if you look at Section 5 of the NPA Act, it says you have the NDPP, then you have the deputies who are all part of that office. But there are various functions that they can perform. So they might be... I think it's... So in her case, she was the second in command of the NPA nationally, right? But if she had said, my role in the NPA had nothing to do with TRC cases at all. I didn't know what was happening about putting together the prosecution of TRC cases in 98 and 99. That would have gone some way to alleviating concern. And that is why the cases say non-disclosure fuels the smell as opposed to dealing away with the smell, because my client says, but why isn't she coming clean? It heightens the apprehension.
That's the fact that your client, in his previous role, may have some knowledge about the chairperson's role, have any bearing at all in this application. That you knew back then, you appointed me, or I was appointed this person to perform this function, and you cannot come today and say there is some institutional bias. Does it play any role, if any, at all?
So my first answer is it doesn't, because he was appointed for specific roles, not to investigate failure to prosecute, which is what she's now doing, bearing in mind her prior roles. But even that is not a complete answer, because not all of the facts complained about are in the public domain. So it's in the public domain to the knowledge of my client that she was in the TRC and she was in the NDP. She was NDP. But he doesn't know what she was doing in the NPA regarding TRC cases. And he complains that, I understand you did advise on TRC cases, and she doesn't come and say you are wrong. And that will be stuff that's in her drawer. It's not something that's in the public domain. You're not going to find on the website of what she was doing but if you want to know what the unit that he says he understood she was working with was doing, you will find that in the statement of Justice Saldana, who was the chair of that unit, at 001-992. He says it was dealing with TRC cases, and it provided advice. It produced a memorandum or report to the NDPP regarding the prosecution of TRC cases. And some of it, in Advocate Nuka's case, he says some of them were not prosecuted because there wasn't sufficient evidence. They were not winnable cases. It might be that the investigation finds that that was a mistaken position to adopt, and that those should have been tested in the courts, as we know of another case which initially started off on that basis, and now my learned friend is busy fighting in the courts. So it is very well to say, but I'm only looking at interference. But interference is not assumed. That's why the terms of reference say whether and if. Because if they were assumed, all that the commission would be about is who did it and when and for what reason. But it's if. So it's possible that ultimately the real reason for the failure to prosecute is internal to the NP. And there's an additional point which would worry my client. There is a judgment of the SCA in Rodriguez. That judgment says the executive interfered with prosecution of TRC cases, and is based on confessions evidenced by NPA officials in which my client and the executive were not parties and didn't provide any evidence. When my client tried to do that in the Pretoria court, this Pretoria court where they want damages, to put his side of the story, they said he's got no interest and kept him out. So you're starting at a premise where there is already a perception upheld by a court that the executive interfered, and that's based on NPA evidence, and somebody who was in the NPA is investigating that very issue, whether the cause of the failure to prosecute is political interference or some other reason internal. So we submit, and recusal calls for a normative inquiry. It's not an easy 1 + 1 = 2. It is a value judgment, and we submit that, and you must put my client in the position of a reasonable person, just knowing these facts and not having full disclosure and entertaining this apprehension. It is wrong, we submit, in that context, to say that the apprehension is unreasonable, because you haven't proven facts about what exactly I was doing in the NPA regarding TRC cases, when that knowledge is only known to you.
So finally, you would contend that in as much as your client has been asked to appear before the commission sometime in September, following the subpoena, this is one of the factors that are in the interest of justice, demonstrate that you should obtain that relief. Because if your client does not appear before the commission on the date, consequences may flow from this.
We know the consequences.
I don't know the consequences.
My learned friend represents one who was victim to those consequences. If he doesn't appear, he breaks the law, and there are consequences. So that's why clarity and certainty is required, both in the public interest, for the interest of the families and the public and my clients, that it's clear that that commission is properly constituted and my client must appear. If it is not properly constituted, it's not the end of the case, of the matter. The president can constitute a proper inquiry and it can carry on and investigate this very important matter. And my client is ready and willing to account. He had wanted to be the first witness to this inquiry if it was properly constituted.
Would you criticize a president of a country for filing an explanatory affidavit and explaining what he said, to say, I did not know the facts. Had I known the facts, my position would have been different?
No, we can't, because my client too says, I didn't know the TRC bit in the NPA, and you're still not telling me. But what I understand is that you were involved in the early stages of TRC case prosecution. So what happened at the early stages could very well have contributed to the failure to prosecute, but you were part of that. Now, President Ramaphosa is and the majority in the High Court says he did the right thing to explain his position, that he would not have.
Well, they use the word commendable.
Commendable, absolutely. And we commend the use of that. It is correct. And it is worrying that even the appointing authority says, I'm worried about public confidence in the commission, given this. So clarity is absolutely called for in all respects, we would submit.
Thank you.
And of course, we rely on what we've said in the application for leave to appeal in this regard. If I can just give the court the references where we discuss the proper application of the tests. It is at the paragraphs 237 of the founding affidavit in this court to 239, and is page 001-215, and to be read with 295-2 295-303, that's the page, 295-303 is the paragraphs, additional paragraphs, at page 001-23. And the test we submit is set out, if I can just complete that answer to that, the debate with our learned friends for the Kalata group is they say, but it is unclear that SARFU at paragraph 76 and 70, Benet at 78, were setting a standard for assessing prior associations, and whether these prior associations here are similar to those, because they, in the case of SARFU, we were dealing with political associations, prior political associations, and in ABSA it was prior commercial associations. But what they overlook is that in both paragraphs, in 76, this is what I can read, is in our opinion, it follows that a reasonable apprehension of bias cannot be based upon political associations or activities of judges prior to their appointment to the bench, unless the subject matter of litigation in question arises from such associations or activities. So it's not limited to associations, also activities. Institutional roles, activities, he was all involved in activities prior to appointment as a commission. It's the same is emphasized paragraph 28 of Benet. Prior association with an institution cannot form the basis of a reasonable apprehension of bias unless the subject matter of litigation in question arises from such associations. So if I can just underline the point. So when Justice Khampepe says, show us a logical connection, what she needed to, the question she needed to ask, to answer that question, was this question in these paragraphs. Not the question whether there's a clear identity of issues between what she did prior and what she's doing. And that's where the mistake was made. And as regards the timing, that's where the mistake. She referred to the right judgment, but just did not rely on the correct paragraph. The paragraphs she quotes when assessing logical connection are the paragraphs in Benet which deals with financial interest arising from shareholders. And those are discussed in Benet around paragraph 56. That's different in the test here. This is a test. This is the standard you are saying as a start. Prior associations per se do. But if the subject matter litigation, in this case the inquiry, arises from the prior act, then a reasonable apprehension of bias can arise. And that she didn't answer. And we submit, if she had answered that question, she would have found against in our client's favor. So Justice Majid, I just wanted to question, but I am conscious that I thought you wanted to ask a question. I'm not inviting it, Justice Majid, I'm just saying, no, my mistaken observation.
No, I'm shocked because I think you can read minds. Yes, I said to the DCJ, I only have one question, but based on the precedent set by my brother Rogers J, I have one extra one. I'll ask them. The first, on behalf of the Kalata group, Mr. Butler submits there should be a higher threshold for commissions of inquiry, members or chairpersons. Let's say just say members, because A, they don't perform on adjudicative functions, they are just merely make findings of fact, and secondly, they don't make binding. What do you say about that?
So we don't understand our learned friends to be saying that fairness doesn't apply to commissions, because that principle applies, and Corruption Watch establishes, and commissions of inquiry also work within the principle, the confines of the. So you can't say you can have an investigator closed hearings and not an impartial on the issue. In fact, the Main Guardian judgment of Justice Nugent makes it very clear that an investigation which is not approached with an open mind is not an investigation at all. Now, those principles implicate a bias, so you can't have a biased investigation. So that applies to commissions of inquiry. When our learned friend says a higher threshold, that threshold can't relate to the accumulation, the quality of the evidence you must present. Bias is clear. The standard says it must be double reasonableness standard based on facts. The facts here are common cause. The only difference is the implications of those facts. If by that they say you must be more permissive for potential apprehension of bias existing in commission, even when a complainant raises the complaint, must allow the commission to say that's wrong. That's wrong because that's wrong. It strikes at the very heart of our, whether one looks at under Section 33 of the Constitution about fair administrative action, or whether one looks under Section 34 of the Constitution, one of the fundamental values of our Constitution and SARFU emphasizes fairness. So you can never attenuate the application of that principle against bias, given the nature of proceeding. What that might enter the fray is when you are asked to review final findings. There, the appreciation of the nature of the role that commissions play would be important, and that's why in Corruption Watch you don't apply the highest standard of administrative opacity, you apply the lowest standard of legality. And that strikes the appropriateness about appreciating. That'll be our submission.
That's my second and last one quickly. You rely heavily on SARFU for this, you and Mr. Mpofu, for this question about whether the collective should have made the decision and not just the chairperson. Now, in SARFU, remember there it was not only against specific judges, it was against Shaskelson P, Langa P, Sachs J, Koop J, and Krichle J, but also the court as a whole. And that's made clear in paragraphs 15, 34, and 65 of the judgment. Now, the applicants make the point that in the first paragraph of the judgment, the recusal application judgment of the three SARFU judgment, in paragraph 2 of the order, the court holds, the applicant has failed to establish that objectively regarded there are grounds for any of the four judges to recuse themselves. I said 5, but it's 4. And then each of the 4 judges concerned agrees with this conclusion as far as it applies to himself and declines to recuse himself, and the application for recusal is dismissed. But that was done in the individual judge's case, but also for the collective. So isn't SARFU on that basis then distinguishable? Because you have there an allegation directed at certain justices of but also the court as a whole.
Yes, I readily accept that the facts are distinguishable, but our reading of SARFU is that there is an underlying principle which informs why court, and I also accept the utility of the precedents in that regard set by SARFU, because the parties seem to have made submissions to the same point, supporting the collective decision. But there is an underlying principle we think informs why it is probably constitutionally proper that it must be made by, is that there is a duty on the other panelists not to sit with that panel member if that panel member refuses to recuse themselves where they should. So it does mean that the other panel members must apply themselves to whether recusal was indicated. They can only do so if they know what the person knows. So if you take our present case, we complain that the chairperson, maybe the chairperson didn't have to file and put a statement of fact saying, as Justice Matopo said, my role in the NPA is X. That would inform the others to form a view whether she ought to recuse herself or not, and whether they have a duty not to sit in that panel forward. And we think that underlying principle is important to inform the need for that collective nation. Because the deficiencies suffered by one member vitiate the whole panel, and that was made clear in State versus Bason. Sorry, the HPCA, it's not the HPCA one, the one in the SCA, that if one member ought not to sit, the whole panel is not constituted.
This is the Bason matter. I think you've answered my question.
Can I just give, and then the second answer to that, Justice Majid, is that here, unlike a court, we're dealing with a creature state. So she can only decide if the empowering provisions say she can decide. And neither the Commissions Act, the regulations and the rules were issued by her as empowered by the regulations and Commissions Act. Those rules don't, she can't take it for herself. So that answers the distinction with South, the last one, because it stands on its.
Mr. Manech, can I take you back to the Section 47 interpretation, and specifically the distinction between judges in active service and retired judges? If we accept the threat of vexatious litigation or abuse as a threat to independence of the judiciary, what is the reason, or how does that purpose come to an end or becomes inapplicable in relation to retired judges?
Is that vexatious litigation related to judicial function as a retired judge, on our submission, is protected. If you call back, is protected by Section 47. If you call back as a retired, perform judicial function, and there's litigation arising from the control mechanism in Section 47, will be all protected. But if the vexatious litigation in relation to chairing inquiry, a commission of inquiry.
Before we get to, I will go to the distinction between judicial to non-judicial duties. I just want now the distinction between judges in active service and those that are retired. Why are we saying that the judges who are in retirement, or just generally, that the spectre of vexatious litigation doesn't affect the judiciary or judges in general, to the extent that retired judges should also be protected?
So our submission is the spectre of vexatious litigation as regards judges is important under the statute when that might be judicial, because then it's judicial. If vexatious litigation is, but I'm retired and farming elsewhere, where I'm facing vexatious litigation, that has nothing, that doesn't threaten the independence of judiciary.
So why doesn't the spectre of vexatious litigation after I retire not threaten me now whilst I'm doing my duties, knowing that what I'm doing now may have repercussions later
because
when
you know
I'm retired?
Because you know that if that vexatious litigation relates to judicial functions now, then you have the protection. Because it's the judicial function that...
I'm not sure, perhaps I'm not sure what we mean by vexatious litigation. Does it necessarily relate to a particular case or it may be just vexatious litigation that, drums up something out of, nothing that you may have been seen doing at a country club or whatever. But because a litigant is aggrieved by a decision that you took, then that is the manner in which they act out their revenge.
Yes. So the way we understand the Constitution is it is consent to protect judicial independence, and it wants to ensure that judges function without threat that what they do, which makes other people unhappy, might result in. And Justice Mlambo expresses that very well in that judgment in Mutata J. That's the primary concern. It's not simply because you were once a judge, we are concerned to protect in all respect in relation to litigation. If you're retired, you've been retired for 10 years, you've never been called to any service, but you've knocked my car and I sue, and that's vexatious. With respect, we'll be extending the purpose in our submission of provision to say, even in that case, you require judicial function before you can be sued, which is completely outside the concern of the legislation.
It's just that I can imagine litigation that's vexatious that may not, on the face of it, relate to a particular case that one did when they are in active service.
Yes, and you would need some evidence to show that there's a linkage with that judicial.
Well, perhaps
function.
that's why the legislature then says, I'm going to protect all judges. And that's why Section 47 is couched in the terms of any judge. Because it may be difficult to make that distinction and work out which cases are related to specific decisions that the judge makes whilst in active service, but now is retired.
Yes. So that paragraph 3 of Justice Mlambo's judgment that the court with regard to, what it says is that really the need to protect judges from unwarranted litigation is the core function of judges is the adjudication of disputes involving the judgments they hand down as well as and their judgment invariably displeases some litigants and sometimes they...
Yeah, but that's in relation to the administration.
Well,
I'm talking about just which I thought you do accept. That's why I'm asking this question
yes.
of you. Independence of judges and their impartiality as to why does the purpose not, as I understand your argument, and persist even after retirement in order to protect even those that are still in active service. And it seems to me that the language chosen by the Parliament to make the section wide seems to resonate with a deliberate intention to protect all judges, so leave gaps for threats or judiciary.
I understand the question. Our submission, protection of judges against vexatious litigation is not provided in vacuum, provided as a mechanism to ensure that judges are discharged. So if the vexatious litigation arises from performance of judicial function, there is a clear likely impact you are to perform your frank, in judgment, hand down justice as you see. But it must always link back. It can't be just in a vacuum. Judges, if you want to see a judge for anything, for any reason related, any function unrelated to judicial, you must be sifted through, and the head of the office is correct. It is the office, the function that is not necessarily just the type, if I can put it like that. And I'm not saying it with disrespect. I'm trying as best as I can to respond to the question.
No, I understand. I accept that. But I'm glad that you raised the idea of the office of a judge, because a related principle is that office is not really separable from the persona of a judge. That's how in this country we've chosen approach the office of a judge, because in order for that same independence to exist or to be enhanced or to be threatened, general members of the public have to have evidence judiciary, and therefore that is why judges carry with them into all spheres of their life, including the chairmanship of commissions, their ethical principles and the impartiality duties that they hold. So flowing from that interpretation, now we're getting to the office of a judge. Now we're getting to the non-judiciary duties of a judge, that they may not be as separable as you come out to.
But there are certain functions when a judge appointment, like if you sit in private, you're not there as a quasi. You are chosen for the training and skill, impartial, you'll be dispassionate, and you have sift through facts. So you're chosen for your quality judge, given this. But when you sit in there, you're not a judge.
You're not performing judicial duties.
Not only that, but even when you determine the case, extent of your powers and are determined, limited by what the party, the judgments where judges viewed and set aside in arbitration because they carried into that sphere the inherent power that the office gave. So there is a vacation of office when you choose to be appointed in certain positions with performing non-judicial functions. The office doesn't go with you into those functions. Your training and your qualities go with you, but not the office.
So you disagree that approach, that the office of a judge is not really separable from the persona of a judge?
My learned friend read from the constitutional provisions that says when you retire, you vacate, you retain the title and all that goes with it, including remuneration, training, which private parties very much like to use, and the state likes to deal with matters which require an assessment of facts and evidence.
No, I'm not talking about retirement now. I'm talking about active service and doing other duties like chairing, such as chairing commission, as we're talking about now, in active service. Because what we decide here will be of general application. So judges in active service, and actually there usually isn't a distinction, but let's say I accept your distinction, retired judges and active service. My question is whether you disagree principle. Judges really carry the office of the judge with them in their persona they are.
So just to dealing with active retired judges, we make a more humble submission that if you're an active judge and you're appointed to chair a commission, one of the purposes of Section 47, because you are still on the roster to sit in court. So, and that is the position of Justice Zondi. It is wholly distinguishable. Our present case is not a judge or a retired judge called judicial functions. Our case deals with a retired judge asked only to chair a commission and cited in that, meaning not. Now, that judge, when she gets appointed a chair of a commission, she is not occupying office in that position. She has vacated the office, but she's bringing with her title and the presumption that she is likely partially sift through facts. And all of those things are factors which is the question of bias. But it's wrong to say that when a retired judge, when Justice Khampepe sits as a chair of the commission, she sits in an office of judge. No. And she says so in her own ruling. She doesn't understand herself to be sitting there for judicial function. Because if she did, she would completely contradict the argument of our learned friends that, the argument of our learned friends, yes, for the commission, that the ruling does not, that findings of a commission could be actually, because it would sit in contradiction with she doesn't have judicial function. They can only write one of those. And we submit that Justice Khampepe is correct. Because when SAFU says you are appointed provider, you're not doing the office of, you're doing that. Appointed as because you're a judge, true, but that's because of your training and quality.
Okay. So that is section 77?
176.
176.2. Okay. Can I just ask something else then about the definition of service and the importation of that definition into Section 47 of the Supreme Court. And I must say I accept your submission. Importation from different statutes, the interpretation needs to be treated with caution. But as I understand the principle, it is not that, it is never that. And a related principle is that actually statutes must be interpreted such that there's harmony in the interpretation of statutes that relate to the same text, content and text. So here, what would you say is the distinctive context that renders the two that definition, of definition undesirable use?
Yes, we would say there are two. The first one is fundamental. If you take independent IIE, the one I referred to, and there you have the definition of universities and what the meaning of it. One is defined, the other one is, can you borrow from the other, or does it mean in provision ways that it carries its own income? The first problem is when you read 47.1, there's no reference to service. So what are you importing that definition to interpret in one? Because if you had an undefined concept of service in section 47.1, then I would understand the need to go and borrow a definition, a sister legislation, so to, and use that definition here. But you don't have the concept of service in section 47.1, which is interpretation.
Well, I mean, but Section 176 of the Constitution uses the same word, service.
But you're interpreting Section 47, Justice Sisi.
Yeah. What I'm saying is, Section 47 relates to civil proceedings against judges, and it says no more than that. It does not talk about. It does not say anything about service, right? And then the Remuneration of Judges Act talks about regulates service of judges. Surely, except if you can explain to me what inconsistency, why it is. What conflict is there between the one section 47 and that statute, and specifically the definition section, or the particular definition?
So that relates to the second problem I was going to raise, is that the two statutes are not in parliament. They're not dealing with the same. What the remuneration of judges deals with, it deals with judges, yes. But it deals with judges' conditions of service, remuneration. And it says a judge is entitled to performing this function. It statutorily says. Otherwise, if you were performing a commission service, an appointment by a minister, need some about how you. If I can just go. So what the section makes, judges are entitled, at least in relation to this service, to the extent that service is. But it's regulating the entitlement. The Superior Courts Act, in the section that we're dealing with, is concerned with the administration of courts and judicial and how taxation relating to judicial funds. It's got nothing to do with what they're going to be paid. So they're dealing with. So sometimes you can have.
They're dealing with two different aspects of relating the same persons, the same office bearers. One deals with one aspect, and the other one deals with different aspects. But Section 176(2) of the Constitution also refers to service, and I don't see any consistencies there, such that all of these cannot be interpreted nearly.
Justice, so Section 1 section in the Constitution would only have an interpretive value to Section 47. I'll guide you on how you interpret 47. You can't now say the proceedings against judges are regular. That's the rely on Paja and Constitution, subsidiarity. So you look to the section, the bigger provision helps you in it. But one can't say just because the judges is in pari materia with any statute that judges will be mentioned in many statutes, including the JSC Act. You can't say then you can take any definition in the JSC Act and superimpose it on the Superior Court because they all do this.
I understand
the subject matter must be what they are regulating.
I understand that. That's why I asked you to or help me pointing to the reasons why they can't harmoniously. But I hear what you say.
It's not reading harmoniously here. We're not concerned with reading harmoniously. We're concerned with importation of a definition into a statute that deals with a completely different subject. Because this importation is not...
Well, reading statutes harmoniously is a law of interpretation.
Yes.
And if we don't do that, we might end up causing chaos in how statutes and sections of statutes relate. We are required to do that.
Justice Zambuza, I embrace and I agree the principle that even before you reach the conclusion that statutes are inconsistent, try to. But what you're concerned with is not a harmonious judges to me, a simple harmonious. What you're involved with, importation, holers, bowlers, definition into the statute which doesn't even mention service, without even dealing with why that is permissible in light of this court's judgment. You will see the majority doesn't even engage with it. Assumes that it is permissible to import that definition into Section 47, and they don't engage with what is the concept in 47 which defining, which is mentioned, but which justifies that interpretation. Justice Zambuza, that's the submission I can.
Mr. Manager, can I follow up on a question that was posed to you by Justice Rogers of whether we would still have to reach the other review grounds if the point about the improperly constituted commission is good? On my understanding, if that point is good, to me it would suggest that essentially that body has not made a decision. Would you go along with that, or would that be a mistake?
Justice Nuku, you're 100% correct, and the usual outcome in that case would be to refer the matter back to that body to make a decision because it has failed to make a decision. The argument we make is that remittal in that context would not be in the interest of justice for all the reasons that we've submitted, which we submitted under direct access.
You've anticipated me. That is why I was going. But now, would that not constitute something more than substitution? Because essentially, where that body has not made a decision, it should make a decision. Because then what is there to review when there is no decision?
So Trencon does grapple with the notion whether when you exercise the power of substitution, you are trenching on separation of powers. Because in this case, what you're positing is that power is allocated to that body to make the decision. That body hasn't made a decision. Why can we substitute? It says, no, when you exercise the power of substitution, you are really just achieving...
Before we get to substitution, sorry to interrupt. What would we be reviewing? Because we would have said that body has not made a decision. And I think that would be factually correct. If it's made by one of the members without the others, does it not follow that then that body properly constituted should then make the decision?
So what I accept is the proposition that that is the usual where a body hasn't made a decision. But when you review and set aside, you will be reviewing this decision because this decision must stop to exist because it wasn't made by a body that was properly constituted. The question that arises then, what follows? What is the remedy having done that? What Justice Nuki is quoting to me is generally you would refer it back to that body to make a decision afresh. That is correct. That is the default position. But we are asking that there is a case to depart from the default position here for the reasons we've mentioned, delay, fairness, the public interest, the interest of justice, it's a foregone conclusion. All of those you are entitled to substitute under the Trencon principle, and you're not trenching on separation of powers. It is perfectly consistent with the Constitution to substitute where there is a case for substitution. And Justice Mudiba's judgment provides you with material on which you're applying your mind because it's not as if nobody spoke about this in the High Court. Mudiba J grappled with the same issues that we're asking. Thank you, Justice.
Thank you very much, Advocate Maini.
Thank you, CJ. And the Justices.
We've not had time to break properly, so we're going to adjourn for 30 minutes and then come back and hear the respondent.
As the court pleases.